ವಾರದಲ್ಲಿ ಆಯ್ತೇನಪ್ಪ.
ಕ್ಲಿಯರಿಂಗ್ ಇಲ್ಲ, ಅದು ಎಕ್ಸ್ಟ್ರಾ ತೆಗಿಸಿರೋದು ಯಾವ್ದು ಇರ್ಬೇಕು. ಇದಿಲ್ಲ ಲಿಸ್ಟ್ ಅಲ್ಲಿ, ಲಿಸ್ಟ್ ಇಲ್ಲ ನೋಡಿ. ಕ್ಲಾಸಿಫಿಕೇಶನ್ ಅದು ಲಿಸ್ಟ್ ಇಲ್ಲ ಅಂತ. ಹೌದು
ನಾಳೆ ಮಾಡಿಸ್ತೀನಿ. ತಾನೆ ನಾಳೆ ಏನು ಎಂಟ್ರಿ ಮಾಡ್ರೇನು ಇಲ್ಲ ಅಲ್ಲ. ಲಿಸ್ಟ್ ಬರುತ್ತೆ ಇದೊಂದು ಫೈಲ್ ಅದಕ್ಕೆ ಸೇರಿಸಿ ಬೋರ್ಡ್
ವಾಪಸ್
ಎಲ್ಲ ಸೇರಿಸಿ. Yeah, come on, wait to the instruction. ಮನೆಯಲ್ಲಿ ಬೇಕಾದ್ರೆ ಫೋನ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ ಆಮೇಲೆ
What is that order passed by the trial court? When that order is passed? The order passed by the trial court. Next week, 2022 matter.
Number one, serial number 2 to 6. Page number 2, serial number 7 to 13. Page number 3, serial number 14 to 17. Page number 4, serial number 18 to 25. Page number 5, serial number 26 to 33.
29.
Serial number 29, Batavanna came for petitioner.
Yes. Yes. At the request of the parties, leave this matter next week. Interim order granted earlier is extended till next date of hearing. Further, next week. Interim order is there in your favor. No, then why you are moving that matter? You will hear. It is for adjournment, mister. If you want to argue, wait. Both you can't do it. Yes.
Page number 6, serial number 34 to 44.
39.
Kalyan R for appellate.
You are appearing for? At the request of counsel for the appellant. Yes, there is an IFR vacating. Yeah, have you informed other side?
Serial number 39.
Yes, you inform and move. Yes.
Serial number 40.
Yes.
For R3 and R4.
Yeah,
And
inform.
respondents.
Yes.
We have it on 18.
At the request of counsel for
I appear for the appellant, my lords, in the serial number 40.
next week.
It may be a date may be fixed, my lord, Friday, next Friday.
Next week it will come. Yes. 43.
Chandranath Ariga case.
Yes. You have no objection. Yes, at the request of counsel for the respondent, leaves this matter next week. Bharat, next Thursday. Yes.
Page number 7, serial number 45 to 51. Page number 8, serial number 52 to 58. 53, Anandarama K for petitioner.
Yes. The request of counsel for the petitioner next week. Matter granted earlier, if any, is extended till next date of hearing.
Page number 9, serial number 59 to 61.
My lord, 59, 59.1 and 60, my lord.
Yes.
Appearing for appellant.
Yes.
KG Shantaraja.
I beg for your time, Your Honor. Kindly post it on
Yes,
16th.
they
or
want time. Yes, at the request of counsel for the respondent, appellant,
Appellants, my lord.
use this matter next week. Yes.
Much obliged.
60, 59, 60.
Page number 10, serial number 62 to 65.
Yes. 62. Yes. Yes, use this matter next Wednesday. Yes.
Page number 1 for being spoken to, serial number 1. Mr. Thomas, petition party person.
Interim order by oversight that will be extended. The problem is this matter has to be before that other court.
Yeah, CPC. Twenty-three. 19 Sham Prasad side, bro. 20 Pandit side, no. Pandit side, from 20 onwards.
Yes. Wait a minute. When that interim order pass? Issue notice. Yes, it's code. By order dated 9/6/2023 has granted an interim order. Same is extended time to time. On 7/8/2023, by oversight, interim order has not extended. Interim order granted earlier is extended till next date of hearing. 21. Post this matter along with the WP number 16031 of 2023 on 24th before the appropriate bench. Yes, sir.
For order serial number 2, R.A. Devanand for petitioner.
Non-compliance of this objection. Pass out.
Serial number 3, Mohammed Taib for petitioner.
Ahmad Tahir. Yes. Nana, why you are not making respondent number 2 as a party? Yes, you have to make a party and you can seek for a dispensation. Yes, you not amend, you just amend this cast title. Yes. Day after tomorrow, you do it. Yes.
Small issues, the bar has 85 or perfect to deal with any issues.
Yes, learned counsel for petitioner case. He will do that needful by end of this day. Leave this matter tomorrow. Yes.
Serial number 4, remove for petitioner.
Non-compliance of office objection second time. Each time is granted to comply the objection. You comply today, you move that tomorrow. No, why you have not complied? First comply and move it. Yes.
M. Ganesh for petitioner.
Yes, then it is a decree. You have to file an appeal. Yes, application is allowed. Then it amounts to a degree. That is what that you have to file an appeal. Liberty always there. It is under law. Yes. Learned counsel for the petitioner has filed a memo seeking leave of this court to withdraw this revision petition to approach appropriate legal forum. Taken on record. The above writ petition is dismissed as withdrawn. Liberty to approach appropriate legal forum.
Serial number 6, for petitioner.
On complaints of office objection.
If we are not opposed to the application filed by the defendant.
You made them as a party and dispensed that notice.
Those you have taken that are not opposed, the reason you have not made them. There is some urgency for the reason that the High Court in its order given a direction to dispose of the claim within a period of 6 months. It is filed by the petitioners and that's why only they are being.
No, what is the rule actually? What is the rule? High Court rules. Whether all has to be made as a party or you can make in a party whoever you want. No, that's I am asking to assist the court. What is the rule? What is the rule? You verify that rule. Which is the rule which says whether it has required all the parties before the trial court has to be made as a party, or only that concession can be made as a party. You just assist the court on that. Yes. Pass out.
Number 7, Jairaj PS for petitioner. Vijay Kumar C.
Yes. 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 Scheduled column number 3 to be stated.
Stated.
Where?
32 is number 32. These suit schedule properties.
32.
Page number 32.
Yes.
Then you see suit schedule property rank 2 and 3.
Yes.
Clearly, suit schedule item number 3 and petition schedule property. The subject petition schedule property which I am claiming my rights of
Yes.
has been clearly mentioned.
Suit scheduled properties and the land.
Yes.
What is that? Suit scheduled property and a land. Suit scheduled property 3 and petition scheduled property is under.
Good property.
Hmm.
Good property I have incorporated.
Hmm.
In so much my claim is concerned. It is with respect to the suit number, item number 3. Stated specifically. This objection is column number 3 to be stated correctly, memorandum of petition. It should be over.
ಅದನ್ನೇನು ಹಾಕೋ ಪ್ರಶ್ನೆ ಇರಲಿಲ್ಲ. Petition scheduled property ಅಂತ you need not. Yes, only that when you are arguing, you can say that scheduled 3 is that. Yes. In what is that other office objection? Photocopy of the IA. Then photocopy of IA. I have filed it.
Page 156. Also filed here for dispensation. The objections are to be
Dispensation prior to be stated correctly. IA 1 of 2023. Yen dispensation ಕೇಳ್ತಾ ಇದ್ದೀರಾ?
all the records produced before the trial court have made
The reason stated accompanied with this most excited by this animal document please to dispense the production of type and the copies of
Adjourned.
where is that copies?
series one. These are the documents that are.
Heard the learned counsel for petitioner on office objection. Submission of learned counsel for the petitioner is accepted. Office objection is overruled. Post this matter for admission.
The editor is also there.
Oh,
We dispose of the matter.
yes. 21.
70.
Yes. 17th. Yes.
Number 8, Ramachandra X for petitioner, Balachandran BS.
On filing of authorization letters with respect to that P1. Huh? No, what is that they are required by that? Sneha developer proprietor concern. Proprietor. It's not a company. Yes. What is this matter? Yes. Learned counsel for in respect of office objection. Submission of learned counsel for the petitioner is accepted. Office objection is overruled. Post this matter for admission. ಎಷ್ಟನೇ ತಾರೀಕಿದೆ ಅಲ್ಲಿ? 14. ಎಲ್ಲಿದೆ ರಜೆ? There is no holiday. Monday. Yes. You don't have a holiday. If you have an holiday, you can take. It is not declared. It is not declared. Yes, let us. Yes.
Number 9, Rajshekar S for petitioner.
Yes. That counsel for the petitioner submits that needful has been done. Office to verify and proceed further.
Case number 10, D.K. Narayana Swamy for appellant.
Non-compliance of the office objection. Still office objection, it necessary deposit court fee has not been paid. Valuation to be made correctly. Is in your name, wakalat. Either comply it or will dismiss it. If they are not interested, what to do, madam? In all cases, they are saying that central government has taken, but nobody is representing. We are told that there are 75 central government advocates are there. Yes. Yes. Finally, week's time is granted to do the needful. Comply the top subjects.
Case number 11, C. Vishwanatha for appellant.
Week's time is granted to do the needful.
Case number 11, serial number 12, G.S. Venkata Subbarao for appellant.
Council submission with regarding to the topic objection. Father name of the appellant to be correctly stated. Yes, Mr. What is it? What is the father name of the appellant? ತಾತಪಯ್ಯ. ಕೆಳಗಡೆ ಕೋಟಲ್ಲಿ ಏನ್ ಹಾಕಿದ್ದೀರಾ? ಟಾಟಾ ಬಯ್ಯ. ಏನಾದ್ರು ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಹಾಕಿದ್ದೀರಾ? His name is ತಾತಪಯ್ಯ ಅಂತ. ಆಯ್ತು, ಒಂದು ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಹಾಕೋದಲ್ವಾ ಅವ್ರ ಹೆಸರು ಏನಿದೆ ಅಂತ. Yes. Or the learned counsel for the appellant on office objection accepted that submission of learned counsel for the appellant office objection is overruled. Yes. What is that? No, which is that serial number? Oh, non-compliance of other office objection is there. Huh? Value of that appeal to be stated, considering all statutory benefit and if necessary, second steps to be filed. Where is that valuation you have stated, Mr.? The appellant has preferred that above appeal seeking an enhancement of the compensation sum of rupees 10 lakhs with the interest. The compensation claimed is as per the Karnataka court fee and suit valuation. Therefore, the present appeal for the purpose of. Now that what is that valuation? See, you clarify everything. What is that award amount? How much it is award? What is the total amount? How much you are seeking for an enhancement? Yes, award agide, yes, enhance agide, yes, ಕೇಳ್ತಾ ಇದ್ದೀರಾ ಅಂತ you have to clarify, Mr. ಅದು in respect of office objection in respect of the name of the father of the appellant is concerned. Submission of learned counsel for the appellant is accepted. Office objection is overruled. In respect of other office objection, week's time is granted. Apply the same.
Serial number 30, Vishwanatha Reddy for appellant.
Yes. No for acceptance of paper publication R103. Yes. This court by order dated 28/6/2023 permitted that appellant to take out notice to respondent number 113 by way of paper publication in Vasadiganta Kannada Daily Newspaper, Bangalore edition. Pursuant to that order dated 28/6/2023, the appellant has filed memo or enclosing paper publication. Respondent number 1 and 3.
Respondent number 1, T. Shivanand. Respondent number 3, C.G. Rajesh Karambaya.
Called None appear. Memo is accepted. Service of notice to R1 and R3 is held sufficient. Yes. Service completed. Post this matter for admission.
Serial number 40, Sriram Timappa. For appellant. Serial number 14.
Yes. Let's see what is the concept. The RPHT order dated so. Scheduled to be stated correctly at IA number 2 as per the schedule mentioned in that IA before the trial court. Valuation para to be stated in the appeal memo. Remaining scheduled details to be stated in IA along with the schedule. There are what is that deleted? Where is your IA? What is the suit for? Why that some of the suit scheduled properties is not incorporated?
Because they were sent to UP, so section of the party. I still not this for that.
You are seeking injunction only in respect of.
Other
You are seeking only injunction in respect of Schedule A and Schedule E.
yes.
Yes. No, that is true. You are seeking injunction in respect of that, but court fee has to be calculated what has stated in the trial court. In the appeal, you cannot be stated that only in respect of the Schedule A and B. Court fee has to be stated as per the trial court. Yes. You correct the court fee column. Yes. Week's time is granted to complete. You complete and move it. Yes.
Serial number 15, for appellant, Kamaraju.
Council submission of office objection regarding to non-furnishing of complete pages IA before the trial court, non-filing of acknowledgement having served copies. None appears. Leave this matter 2 weeks.
Serial number 16, Parmeshwarappa MV for appellant.
Time to appeal against the order of this one. What is that order you are challenging? Order 9, Rule 13. Where is that order? Petitioner, counsel, absent, no representation, appeal petitioner is question. Dismiss for non-prosecution. You have to file a restoration before the same court. Order 9, Rule 13. Other dismiss agre, amel appeal hakbodu. Learned counsel office has raised an objection regarding the mentality. Learned counsel for appellant has filed a memo seeking leave of this court to withdraw this appeal with liberty to approach appropriate legal forum. The appeal is dismissed as withdrawn with liberty to approach appropriate legal forum.
Serial number 17, CH Acharya U for appellant.
My lord, beg to appear for the appellant, my lords.
Yes.
Well, it should be, my lord, miscellaneous second appeal, my lord, because the first appeal under section 54 is exhausted.
Yes,
My
it is
oath-
second appeal. MSA. It should be MSA.
MSA,
Yes.
leave may be granted, my lord.
You file a
MS,
memo. Learned
MS, I
counsel
will
for-
file it in
yes.
office.
Learned counsel for the appellant appear through VC has quit that this miscellaneous first appeal may be converted as miscellaneous second appeal.
Please, my
To
lord.
that effect, he will file a memo in this registry. Submission of learned counsel for the appellant is accepted. Office is directed to convert this MFA into MSA. Yes,
Please, my lord, oblige.
statistics. For statistics purpose, appeal is disposed of.
Serial number 80, Mahesh for appellant.
What is that mistake?
Independent has to be included.
Yes, pass out. Pass out, pass out.
Serial number 90, On Kumar T for petitioner, Prithvi Wadayar.
Non-filing of acknowledgements for having deposited the amount before the trial court. Yes.
To produce the acknowledgement for that,
Learned counsel for the petitioner submits that as per that order dated 3/8/2023, they have deposited that amount before the family court. To that effect, they will produce that acknowledgement in the registry by next week.
Number 20. Yes, for petitioner.
Which time is granted to comply the top subjects.
Look application matter, serial number 21. Yes, Balaga petitioner, Suresh P.
Hearing filed by the advocate. What is this matter? What is this matter, mister? ಏನಾಗಿದೆ? No, if you are ready, you will hear you now. Why you are hearing? What is this CRP matter? Both the court has rejected. Huh? Application? Yes, IA 1 of 2023 is filed for admit agitandre. Yes. Heard. IA is allowed post this matter for hearing in first week of September.
Number 22, for petitioner.
Petition filed by the petitioner 25. Yes, issue notice on IA 1 of 2022.
Serial number 23, ask for petitioner, Ravi Kumar.
Yes.
for the respondent counsel.
Yes.
And on the same day, the entry application number 1 will require to apply.
Hmm.
That's not. Of our accommodation.
No, that you can. For 19 days delay, what is your objection? Will continue.
Pertains to interim application, there is no objection, Lordship. Pertains like interim application number 2, Lordship. They sought for the.
Yes, yes.
Protection, Lordship. For that, I have a objection.
IA 1 of 2023 is filed for continuation of delay of 19 days in filing an appeal. Through that affidavit. For the reasons stated in that accompanying affidavit, delay of 19 days in filing an appeal is condoned. IA 1 of 2023 is allowed. Learned counsel for respondent grace weeks time to file objection to IA 2 of 2023.
2 weeks was pending. Instruction from
No,
my
that's
secretary.
Admission matter, mister.
And it's the cannot-
Next week. Yes.
Reason is not there. Date may be given.
Next week and the next Thursday. Yes.
Vijay Kumar K for petitioner.
Yes. Notice.
Same order, not, same day, not, we do not file passing the material of that application also filed. And again, the challenging not is not left out there. Okay, please.
Yes, notice has to go. Yes.
Yes.
You take hand summons without condoning the delay. How can I get? So, eminent notice. In addition, petitioner is permitted to take out notice to counsel appearing for the respondent before the trial court. Permitted to serve a copy on counsel appearing for. You serve it and move it, mister.
Number 25, Venugopal MS for appellant.
Yes,
Rejection of their idea.
notice, notice. Including why?
Before the trial court was sought again, those including the respondent.
Hmm.
Pleading application was not decided by the trial court. My application under 13 is decided. Therefore, they are not in the past tense of the trial. Therefore,
You could have made it them as a respondent here.
added
Office objection Agdaga, you could have said that this can be, this is the reason you have been made as a party.
I was clarified in the note itself. In the note below the past tense.
Then also you have filed enough. They are already in that cast list. Yes. And also issue notice on IA 3 of 2023. Yes, issue notice on IA 1 and 3 of 2023.
Serial number 26, Kumakara is on the petitioner, SN Bhatt.
You have filed an objection. Copy sir Madi avrige. Yes, you want time to see what is their objection. Majority. What is he? No, that. No. Only son has been directed to be paid till that timing that majority. Now that in respect of only in respect of wife, you have been directed to pay 5,000. Then you have to maintain your wife, madam, at least 5,000. What is that? No, 5,000. See, it is a minimum. Minimum one person's required 5,000. 5,000 unless you show that she has an income, she is working there, she has produced the man. Son living idra, son, it is not his responsible to look after the mother. It is the husband who is not ready to look after. How can you ask the son to look after her mother? Second respondent delete an order itself says till he is attained majority. If he filed an execution petition, then you can explain he is already major. He is 5,000 kinta kadame. Now that you know that percentage of diabetics in India. Diabetic is now it's become a part of the life. No, you show me that no, you show me, produce the document, whether what you are saying that his leg is amputated, he can't work. You have produced, not contention, produce that medical certificate and documents. Then we'll see. Yes. 1 week's time is granted. Learned counsel for counsel for the respondent has filed an objection to IA. Learned counsel for the petitioner pays 4 weeks time to. Already, order itself is clear. Why do you want that further clarification? No, if you want to dismiss me on the merit, then I will dismiss it. then I say that I can clarify. Otherwise, what is the necessity for this court to say all these things? Disposing what? I have to dismiss on the ground of delay itself. That, then why do you want 4 weeks time? Yes. There is a delay of 568 days in filing a petition. IA-1 of 2019 is filed for condonation of delay. Respondent 1 and 2 has filed an objection. Peruse that affidavit filed along with that IA-1 of 2019. The delay in filing the petition has not been properly explained. They have not given any proper reason to condone the delay. On the other hand, the maintenance awarded by the family court in respect of the wife is only 5,000 per month. In respect of second petitioner, son is concerned, it is submitted at the bar that he is become a major. Since maintenance has been awarded to the second petitioner, son is only till he is attaining the majority. The other circumstances, there is no proper explanation for condonation of delay. Hence, the IA hence the petition is dismissed on ground of delay and laches. Yes, I have clarified that he is attained majority. Yes. Now that headache for them to execute and find out where he is there. Yes.
Serial number 57, Venkatesh Soma Reddy for petitioner, Sandeep Lahiri.
Yes. What is the suit for? Hmm. Yes. No. What is the IA file? Reject the claim. What has happened that IA? IA filed by the defendant and the IA is dismissed. Now what is the stage of the suit? Then will otherwise the purpose, if it is suit is complete, then its petition become infructuous.
The plate the real thing is the 2021 gives me that has been challenged by me.
Yes.
There's a limitation of 3 years. In my para 6, I say the date of knowledge is 20 January 2022. They are drawing.
No, if you are ready on that main matter. No, you don't precipitate that matter before the trial.
Yes. I do not read my.
Yes. Learned counsel for the respondent prays some more time to file an objection to IA, and he undertakes that he will not precipitate the suit before the trial court. Submission of learned counsel for the respondent is taken on record. Leaves this matter of 2 weeks.
For petitioner,
Petitioner.
Yes.
Order 7 application is. I advise that the application is dismissed. Therefore, I filed the CRP. Suit for partition and separate possession. We have taken that there was a relinquishment deed executed by this plaintiff in 2010. Suppressing that fact of registered relinquishment deed, where she relinquished all 2021 after 11 years, she filed the suit for partition. So I have the judgment to say that suppression of material fact is a ground for rejecting the plea. The plaintiff, because the non-mentioning of the relinquishment.
No, see, plaintiff has to be rejected on the basis of that pleadings in the plaintiff only. Now that they have to look into that written statement to see that there is a relinquishment deed. That cannot be. You can raise this ground in that main petition.
Yes, but the non-mentioning of that relinquishment date in the plain. It is the
See,
application of material.
If court wants to see whether there is a relinquishment date, it has been done on so and so date. There is a relinquishment date can be looked into only by the written statement. Because in the plain, they have not awarded. Then can it be looked into that and decide?
The question is that I produced that relinquishment date along with the CRP, it is a registered.
No, that is, no, Mr. It is true. But see that plain can be rejected on that ground.
And you see that
Yes.
the Supreme Court.
First, one by one, you just explain and show me that what the point you have to be.
But this Patna High Court is very clear, paragraph 10.
Yes.
I find paragraph 10 and 11.
Yes.
I find no force in the submission to give plaintiffs opposite parties as per provision of order 711 CPC determining the question of rejection on the other grounds mentioned there, plain has to be looked into. But question is that if the plaintiffs have deliberately suppressed the material fact, the disclosure which is required by law to be made under order 602, whether it was open for the concerned to proceed with the trial of the suit after breaking issues. After that, 2 lines, thus it was well known to the plaintiffs and their duty bound in law to disclose the same if they are not done. Order 602 of the CPC clearly stipulates that pleading should contain the material facts. It has been observed by the apex court in this open subject Sunday versus Assistant Commissioner.
Yes.
The omission of a single material fact leads to an incomplete cause of action. And a government complaint becomes bad. Order 7 to 11 of the CPC lays down an independent remedy. Question. Says the principle is that.
No, you read what is that, whether it can be done in contemplate become bad. Order 7 rule 11 of the Code of Civil Procedure lay down that independent remedy made available to the maintainability of the redress of so and so. Keeping out of the court, irrespective of suit, a case prima facie, either suit is abusers of process in the same sense it is to be the jurisdiction to own. Now is well settled that draftsmen were materials to so and so. How to be taking care to the ground mentioned therein fulfilling the clever drafting.
IPC para 20.
Formal reading of them is really part of action has not been. That is no answer. In the present case, it has to be held that involves suppressing the material facts. It omitted searching. Reason that it has been dismissed by the respondent for subsequent suit challenge the same order on the ground that is not. It was liable to be rejected and dismissed. The court will have committed material for the building of this. It is not. It is intended. No, this is in the second appeal. What is the facts? It is not on rejection of plaint.
So on 7 to 11.
Huh?
7 to 11.
Elida, you show me the facts.
This Patna High Court is on 7 to 11.
Where is that? You show me the facts.
And we see this also the head note is
What is that?
section 115 order rejecting plain case.
No, you show me the facts in that case, Mr.
Facts
Civil
are
revision petition is against. Order passed by music there late soon.
facts
Application filed.
previous civil revision petition being listed.
Ideal rate. First pair of the lay order. First pair of the ideal rate. The civil revision petition is dismissed against. How do the learned council revision petition? Order 7 rule 11. Yes. What is that? Supreme Court?
Para 20 in that judgment.
Yes. Yes,
Para 20,
yes.
there is a distinction between material facts and particulars. What's material facts show that the facts necessary to formulate a complete cause of action must be stated. Omission of a single material fact leads to an incomplete cause of action. Statement or claim becomes bad.
This is the judgment which has been relied in this.
Then there is one more Supreme Court old judgment. This is a para 5 in this judgment.
Yes.
It is my lord, suppose if this suit is allowed to proceed, the evidence that registered document will ultimately it has to be dismissed.
Yeah,
Based on the.
now that if relinquishment deed is there, what is that entire suit property has been relinquished in the.
They have mentioned that everything we have given that they have produced along with my CRP.
Yes, Mr. What is it?
What happened? More than 20 properties are there, to seeking
No, have you given a relinquishment deed in respect of entire property? They have produced that relinquishment deed, it is registered.
Page
Yes.
24, man.
Or,
My colleague, madam, kindly.
no, yes, stay up further proceedings in OS number 172 of 2021. Pending in the file of Senior Civil Judge Bagepalli in OS number 172 of 2020-21 till next date of hearing.
Stay was there, my lord. The extension at court, it has come back.
Order made. Interim granted by this court earlier is extended till next date of hearing.
Number 30, Vijay Krishna Bhatt, M for Appal, petitioner.
Yes.
Section of three.
Yes.
Partition.
Yes.
Seventh dependent's father had purchased the property in the year 1994,
Yes.
food schedule property.
Yes.
But in 2018,
Hmm.
some of us have filed the suit
Hmm.
challenging that document and also seeking for partition.
Yes.
Lord submitted the application on two grounds. That first of all, the amended section 6 provides that any alienation prior to 2004 cannot be questioned.
2004.
December.
That if there is any daughters, sons are they entitled? See, before.
That is one ground.
Hmm.
And another ground is under Article 109 of Limitation Act. Now, in a joint family, a senior member can alienate the property for the benefit of the family.
Yes.
It's a voidable document in respect of other persons. They can
Yes.
accept it or avoid it.
Yes.
The limitation is 12 years. 12 years.
12 years.
12 years under Article 109. So
Then the document, the agreement, the sale deed has been executed.
94.
84.
We are in possession, cultivation, now second generation.
No, when the suit is filed.
2018. So then afterthought.
See that limitation. 109.
Not 9.
The alienation takes possession of the property by Hindu governed by the capacity not to set aside his father's alienation and for the 12 years when the alienation takes possession of the property. What is that finding of the trial court regarding that point?
Request trial, that's the only contention, matter request trial, really dismissed.
Yes, heard. Issue notice. Stay of order dated 60. Stay of further proceedings in OS number 492 of 2018. Pending in the file of 5th additional civil judge JMFC Tumkur till next date of hearing. Madam notice.
Petitioner.
My lord, I am appealing for the petitioner.
Yes.
Gift deed has been executed by the father in 2020. 31/8/2020 has not been questioned and not been challenged. and partition is a separate position of the both the two properties have been sought. And that is the reason we have filed Order 7 Rule 11A and D. No cause of action.
Is it a registered gift deed?
A registered gift deed dated 20/31/8/2020.
They have not mentioned that.
They are not mentioned in the
No,
that
gift
goes
deed-
to suppression of the facts.
no, gift deed is in respect of entire suitable property.
Yes.
Yes, heard. Issue notice. Stay up. Further proceedings in OS number 189 of 2021. Pending in the file of senior civil judge Kodu till next date. Okay.
Petitioner,
Yes. Hmm. Hmm. Hmm.
Simple market deed.
Hmm.
Or a simple basic tax.
Hmm.
If you created 1 year. That's how sold the property in my favor of 19/20/2018.
Yes.
Before completion of the period.
Hmm.
Taking means a party to be sold.
Hmm.
Recovery of money.
Hmm.
And get the nation of the state.
Hmm.
When it is 68 of the national property act. Right.
Hmm.
When it was changed. Created in the market. One market, proceed against the different.
No, that you can sort for delete your as a party.
You can have 7 to 11 reject the print against me, they get there. No cause of action on the number.
Allah, is it rejection of plaint provision is applicable, or you have to file an application for
Rejection of print.
yes.
Mainly go to paragraph number 68. Like to sue on mortgage money.
68.
Para 68. As 22 refers money.
Yes.
Go to page next page, 68 extract mark.
Yes.
Then para 26 you are again, para 20.
Yes.
Section 68, what gives a right to sue for mortgage money. Where the mortgage are binding to pay the same. As is the case in present suit. For undertaken given by the borrower is lenders and within the 3 years in the date of the creation of the mortgage. Like it may have a right, however, the proviso to section 68 one provides that in such a case, transferee from the mortgage or from the legal representative shall not be liable to be sued for mortgage money.
Yes.
As in the present case, now the mortgage property has been sold to the defendant 150 to 18. They shall not be sued for repayment of the mortgage money.
Yes.
These are the suit has not been for recovery of the mortgage money as a certificate of the transfer property.
Yes.
Legal certificate to the mortgage.
Heard. Issue notice. There are further proceedings in OS number 351 of 20 pending in the file of additional senior civil judge CJM Tumkur till next date of hearing. Emergency notice.
petitioner,
Yes.
Hmm.
Petitioner has filed one suit.
Hmm.
That's 317/9 and respondents have filed suit. Put this suit for relief by injunction.
Yeah.
Regarding respect of very same process. But one suit is pending.
Why rejected?
It's rejected on the only on the ground that properties are different. Boundaries are 100%. We are claiming merits the punishment number 28. They are claiming merits.
Where is that line in respect of both the suits?
Yes, in the page. You prior to that, your lordship has already passed an order so far as Kata is concerned. Permission has been granted those.
No, you'll see that boundary is same or not.
Yes. First, you know, the annexure B, so the suit filed by the petitioner.
Page.
Page, you know, the Page 28. Page 28. What is the boundaries in respect of my property?
Yes.
So only number is east by government land. But it's west by land of Nisham. North by also Papa and so. But this is my property. But they are laying upon the boundaries mentioned in the gift deed at page the
Property belongs to municipal.
Page. 53.
When it property belongs to, then it appears to be a different boundary, Mr.
No, but its boundaries are same. Only because they are laying up Kanishwar number 70. We are laying upon 22.
No, Mr.
They have no
Shivakumar.
title dog.
Boundaries.
One and the same. Boundaries are one and the
No,
same.
there, show me that it looks different.
But gift deed lordship at page 53.
Now that boundary in the second shoot, where is that?
Page they're playing. Page 39. There's boundaries.
See that boundary. What is that east here?
It's by road. But we have mentioned government land. But west by same property. Property belongs to Muncham. Then let's north lordship, let's the north by. They have mentioned drainage, north by. We have mentioned, let's the Avla and Karab Kalvi. Karab Kalvi. South, let's say Devanda, Papa and Devanda. Let's their plans to let's now they have mentioned recent boundary, Ramai. Property are 100%. Prior to that, lordship, the annexure D may be lordship has passed the order. Annexure D. Page 40.
Yeah.
So press, we have challenged.
Yes, you take notice.
Yes. Permit to serve the copy to the council.
Yes, issue emergent. In addition, petitioner is permitted to serve a copy on the council appearing for the respondent before the trial.
Number 34. Yes, for petitioner.
This is the petition challenging the dismissal of Order 7 Rule 11 application. Claim was filed for partition in separate possession by a Muslim male, my lord. He claims through his grandmother, Srimati Khadija. If I may take my lord to page number 33, claim. Paragraph number 7, man.
Yes.
Plaintiff submits that after the death of plaintiff's great grandfather by name Abdul Aziz, his 3 sons and 2 daughters inherited the suit scheduled property. Plaintiff, being the grandson of the first daughter of Sheikh Abdul Aziz, is entitled to 56/5 share. The first daughter is Sayyid Abdul Aziz Khatija B, which can be seen from paragraph number 3 of the plaintiff, page number 30. Plaintiff submits that Shri Sayyid Abdul Aziz is the originator of the joint family. Sayyid Abdul Aziz and his wife Aisha Begum begot 3 sons and 2 daughters, namely so and so, so and so, so and so. First daughter is Khadija.
Which paragraph you are reading?
3, my lord. The first paragraph on page 30. Plaintiff submits that Shri Sayyid Abdul Aziz is the originator of the joint family. Sayyid Abdul Aziz and his wife begot 3 sons and 2 daughters, namely Abdul Razak, Abdul Wahid, Abdul Wahab, Khatija B, and Zahiri B. Khatija B is the first daughter. Now, this is also admitted by the plaintiff in several other places in the plaintiff that Khatija B is to whom he is claiming. He is the grandson of Khatija B. Now, I kindly come to the document filed by them, a partition deed at page number 78 of the documents. This is a document filed along with the plaintiff. Date of death of Khatija B is my lord 28/8/1949.
Where do you find?
Roman number 6, my lord, recital.
No, which page number?
78.
78. Something is signature and all is there.
Please, my lord. The first 2 paragraphs, recital number 6. Whereas the above said Khatija B, daughter of Said, died on 28/8/1949. Lords, may kindly come to page number 75.
Yes.
In recital number 2, similarly.
Yes,
Date of death of Syed Abdul Aziz is mentioned.
yes,
Syed Abdul Aziz died on 13/10/1952.
yes.
My lord, this clearly shows that the person, the great grandfather, the grandmother predeceased the great grandfather. Under Muslim law, my lord, there is no doctrine of representation. The plaintiff who is claiming through the grandmother, when the grandmother herself could not have inherited property, cannot claim through. The plaint has been filed for partition through the grandmother. Therefore, an Order 7 Rule 11 application was filed by us, and this came to be dismissed, my lord. The relevant paragraph of the Order of the Learned Trial.
So if grandfather has died after that death of his wife.
Not wife, my lord. Great grandfather, grandmother. The father has died, the daughter has died before the father.
Yes.
Therefore, in Muslim law, the daughter's family will not get property. The entire lineage of the daughter will not get property. I also have.
No, then where will you go that property then?
It will go to the other share. There are other people in the family, my lord. If my lord may kindly go through my synopsis. I have clearly given
But the sons will get. No,
Sons will
only daughter.
whoever predeceased will not get. Whoever is alive at the time of the death of the person whose property is being inherited will get the property. I will also provide my lord with case laws to that effect from our very high court, division bench of our high court.
Yes.
My lords may be kind enough to go to page number 26 of my compilation. Case laws, my lord.
Yes.
My lords will read para number 8 at the end of that page.
Yes.
To a very limited extent, only the learned civil judge was right. Under Muslim law, no person has a right to property by birth. It is known that there is no such thing as joint family among Muslims. So long as the father is alive, the children do not possess any right in the property. It is only on the death of the father, the children living at that time would inherit. However, if any son dies earlier than the father, then the son's issues would not succeed to the father's deceased son. Principle of representation is entirely unknown to this law, governing Muslim Sunni law. This has also been reiterated once again, my lord, at page number.
Yes, yes.
33.
Yes.
My lord, if my lords kindly comes to the relevant paragraph.
Issue notice. They are further proceedings in OS number 2772 of 2022, pending in the file of 53rd additional
58, my lord.
58 additional city civil and such as that Bangalore till next date of hearing.
My lord, may I seek a waiver of notice to respondents number 3 to 6? They are represented by the same counsel in the trial.
That means
The other respondents, first respondent is the plaintiff.
Hmm.
Second respondent is defendant number 2, who is represented by a different counsel.
Hmm.
I am for defendant number 6.
yes.
Respondent number 3 is defendant.
No, it may be represented by the different council. You are saying that they are not necessary parties because
No, they are necessary parties. Notice may be issued. Please.
Number 35, Parsuram AL for petitioner.
7723 passed by the principal district session judge Mysuru, dismissing my application under section 24 seeking transfer
Yes.
of PHSC proceedings from the fourth additional civil judge Mysuru to third additional civil. What happened, my lord, was my petitioners are, my lord, the father and mother of one child who passed away in 2020. Thereafter, my lord, after the death of their son, the petitioners observed that there are some fraudulent transactions in the account.
no, why do you want to transfer?
The reason is, kindly see the order passed by the fourth additional judge when the counsel for the petitioner was cross-examining, respondent 1 and 2.
No, you are making an allegation against the judicial officer.
I don't want to go to the extent of saying
No.
allegation.
No, there should be a ground for transfer. You have to make out that ground.
Kindly see the.
If that is the ground, you tell me that, then I will see whether it can be transferred
Kindly
and
see
what
the
are that
order.
allegation.
Kindly see the order passed.
No, that is the ground.
The ground, my lord, is that they are not predetermined and not allowing me to cross-examine, my lord, respondent 1 and 2.
Now, where is your application? for transferring the case.
Lord, my memo, section 80 at page 81. So the petition under section 24(5). There are two reasons, my lord. One,
Yes.
I have also filed OS, my lord, claiming right under section 25 of the Hindu Succession Act, saying, my lord, respond 1 and 2, my lord, are responsible to the death of my son. Therefore, a descendant to claim benefits under him. That suit is pending before the third additional senior civil. No, that's good, my lord. PNSC, my lord, will follow the OS. Therefore, my lord, it will be a composite order. Therefore, my lord, on one ground, I sought transfer of the third senior civil judge. Second, my lord, fourth senior civil judge does not permit me to cross-examine, my lord, the respondent number 1 on this ground. My specific contention is that respondent wanted to a dissent title, my lord, due to section 25 of the Hindu Succession Act, because my lord, the allegation is that they are responsible for the death of my son.
That section.
25 of the Hindu Succession.
Now that application is filed under section
24 of the CBC. But more of the pendency of the petition, my lord, I try to stay before the district judge. Only after the dismissal, my lord, I inquire. So kindly see how the order has been passed.
Yes, where is that order?
Third, my lord, page 35. Lordship, you can see the cryptic manner in which the order has been passed. These are page 35. Page 33.
Yes.
Page 33.
You read that point number 1, reasoning.
Please. In this case, the petitioners have sought for transfer of PNSC, so and so pending on the file of fourth additional senior citizen to the court of additional senior citizen. This petition is also pending on the ground that the presiding officer of fourth senior civil judge has expressed so many things about the case, and that court has already on the first petition. When the unwanted incident was taken place, as the court has written the order sheet in 2 times, and the said court is not ready to hear their grievance. Doing all those things, the petitioners are clear about their case. Respondents have filed detailed objection, denied submission, amendments of the petition, saying that PNSC and the original suit are entirely different. Cause of action also different, that merely because the parties are unable, even though petition not made a party, they have been implicated by themselves. It is not permissible or tenable to club the matter or transfer the case from one court to another. The right consequence. That PNSC petition and the original suits are different nature of cases. Cause of action also different. PNSC number so also OS has to be adjudicated separate. The petitioners have sought for transfer of PNSC number so and so from the court of so and so to the court of so and so on the ground that another suit in OS is pending before third additional senior civil judge, and also on the ground the presiding officer of so and so court has expressed so many things about the case, and that court is not ready to hear the grievance of the petitioner. The presiding officer of court additional senior solicitor Mysore is partisan towards the petitioners and that he or she is one-sided, definitely matter should be withdrawn and transferred to other court before taking any administrative action. But the magistrate is bound to follow the natural justice that he or she shall not show any favor of partisan to any party. Arguments of the council of petition are taken into consideration. Definitely the functioning of court additional senior solicitor CTM at Mysore presided by presiding officer will get prejudiced in case PO of that court is not of such a nature. Whatever may be the reason, it is not just and proper to withdraw pay and the court additional senior. Which will transfer the same to the court of third additional senior solicitor for such simple.
Now that it cannot be transferred on the ground that because there are not a similar matter. Only that your allegation that where is that order sheet to show that?
At page 58, that's where the order sheet starts.
Yes.
For the lordship's convenience, you type down the order sheet. Like copy.
Yes.
Start from page 77.
Yes.
It's come to page 79, order dated 6/2/23.
Yes. Heard. Issue notice. Stay of further proceedings in P&SC 20 of 2022 pending before senior civil judge CJ Mysore till next date of hearing. Responding. Yes. What's your name, Mr.? Both 1 and 2. Lavanya. So and so undertake to appear for respondent number 1. Office is directed to show his name. Issue emergent notice to respondent number 2. Yes.
That side, represented by respondent number 1 itself. That side.
Yes, you are representing. Take notice to both. Yes. So and so is undertaken to appear for respondents. Office is directed to show his name. Yes. You serve a copy. Yes. Petitioner is directed to serve 2 sets of copies on so and so council.
Sir, order sheet as per petitioner, civil process.
Yes. Service is complete. Yes. Heard. Heard. Admit. Both is heard and admit. Yes. Imprimatur until further order. Yes.
Number 37, we Raju for appellant, V. Shivakumar.
Yes, Raju.
V. Raju.
Yes. None appear next week.
38, Vijay Bhatt for appellant, Vittal Shetty P.
Yeah, 9 for what? Out of 39 rule.
For using the common passage
Suit for?
to partition and permit injunction by any appellate.
Yes.
The appellant is the daughter-in-law of the respondent number 1. And the sister-in-law of the respondent number 2.
What is out of 39 rule 1 and 2?
The appellant was residing in the first floor lordship. Using the common passage and the regular disturbance of the electricity because the meter was inside the ground floor. Here the respondent number 1 resides. Disturbance of the power supply to the first floor. Because of that reason, this IA was filed because there was an interim order, ex parte interim order in favor of the appellant.
What is that ex parte interim order?
Not disturb the peace because she is there in the first. Her husband was died because of the cancer. So this harassment, the appellant filed this particular IA.
Is it true, Mr. He is residing in the first floor?
I may be permanent.
That is different. Whether you have, what is the, how many floors are there? Ground? Oh, who is- Wait, Mr. I understood your case. Who is there in that first floor? Defendant. Plaintiff is not defendant. Yes. Yes, yes.
when there was a disturbance to enter to the first floor from January.
No, you are not residing the first floor. Why are you going?
I'm residing along with my husband when before his death in the first floor itself.
Hmm.
And continuously the police complaint had been filed before the Rajajinagar police station saying that I had been disturbed and there was a CCTV was being installed by the police.
Now
itself.
I am asking simple question.
Yes, Lord.
Whether you are residing in the first floor or that the area.
My Lord, when there was a continuous disturbance, I am a software engineer. I need a power supply to my work. When there was continuous disturbance, I filed this IA. When this IA was dismissed, they constructed a wall. So I should not enter at all. There's a photograph also been produced.
No, see, you are saying that after the dismissal you have shifted.
After that, there is no power supply. In 2022 itself, I filed the PBMT saying that shift the meter because I am getting the continuous
Simple
disturbance.
question. You said after filing the suit, there is an ex parte injunction order
Yes,
in your
Lord.
favor.
Yes,
Therefore, you are residing there on the.
in the first floor.
Only that ex parte injunction order has been vacated in the year 2022, November.
No.
Yeah, my application was temporary.
It's still and there is no passage also. Passage using the passage was not dismissed, my Lord.
No, see, suit has been filed in the year 2021.
Yes, Lord.
See, till
The next part is granted.
now that order 39 rule 1 and 2 application, which is challenged before this court, what is that order you are
So
challenging?
using the common passage to enter into the first floor
During the pendency,
during the pendency of the suit.
during the pendency of this application, you have any interim order? Not to, disturb for.
ಫಸ್ಟರಿ ಗೋಪಾಲ್ ಅಂತ ಹೇಳಿ ಇಂಟಿ ಮಾಡಿಲ್ಲ 2022 ನಮಗೆ ಈ ರೀತಿ ಪವರ್ ಕನೆಕ್ಷನ್ ಡಿಸ್ಟರ್ಬೆನ್ಸ್ ಆದಾಗ
ಅಂದ್ರೆ 2021ರಿಂದ there is no any injunction.
no, there is no, but there is a coordinate bench order where we in the 2022 when we given the representation to the BESCOM to shift the meter to the common area, so I should not get the there was a mandamus was directed. So the BESCOM to shift the meter to the common area. So this was
No, it is in a case only on temporary injunction.
yes, Lord.
If you are not residing, what is the purpose to take that injunction order?
No, I have been forced out because electricity is the basic necessity for my work, for my food preparation, everything. Because I am a single lady. So,
No, is it that she was residing before that?
Clearly, it has not produced the police complaint. Number of police complaints.
No, that what is the document to show that from which date she was residing in that other place?
Police complaint is
Yes, yes.
because there was cancer treatment was going on at that time, he was suffered cancer, and there is no electricity, continuously disturbance. So I don't have any other option.
No, that who is residing now in that house?
My lord, I have produced the PBX report. They have constructed entire wall. There's no illegal construction.
No, mister. I'm not deciding that suit.
No, Lord.
See, now there is already some persons are residing in that. Taking this advantage, you can't throw him out.
Lord,
If they have entered, then your remedy is to seek for an possession.
yes, Lord.
By this order, you cannot forcibly evict any
There was
person.
expert.
By admittedly, you are not in the possession.
I have to forcibly gone out because of the electricity.
That is what that law says. If you are not in that position, if it is forcefully thrown out, then you seek for a restoration of the position.
But the thing is, there was expert increment. That is also not been.
Or if you want, we can direct the trial court to dispose of the suit. And also, this order has been passed in the year 2022,
Okay, we are finding the January issue.
January. Till that September, we are waiting.
No, December it was passed and January we are finding.
No interim order. Yes. Is there any other respondent to serve?
Both are.
Yes, I will dispose of. What is the stage in the trial court?
IA.
By whom?
What is dependent for rejection of the
Now
claim.
that you cooperate for early disposal, I will direct to dispose of the suit itself.
Sure.
Yes. Both of them has to cooperate. Yes. Because it is your suit.
Yes, Lord.
Yes. This appeal is filed by plaintiff under order 43, rule 1R, challenging order dated 24th November 2022, passed by 17 additional civil and session judge Bangalore in OS number 848 of 2021 on IA filed by the plaintiff under order 39, rule 1 and 2. For the convenience, parties are referred to the ranking as per the trial court. Plaintiff has filed in a suit for partition and separate position. He also filed IA number 9. ಅರ್ಜಿದಾರರಿಗೆ ಪ್ರಮಾಣ ಸಲ್ಲಿಸಿದ್ದು electricity ನೀರಿನ ಕಡಿತಗಳನ್ನು seeking temporary injunction restraining the defendant from not to disconnect the electricity and water connection to first floor of the suit scheduled property. After hearing the parties, trial court has dismissed that application by impugn order dated 24 November 2022. Being agreed by the same, the plaintiff has filed this appeal. Now that issues frame ಆಗಿದೆಯಾ? ಆಗಿಲ್ಲ. Since order has been passed on 24 November 2022 and even during the pendency of that application IN 9, also the plaintiff has no any interim order. Under these circumstances, only relief can be granted is directing the trial court to dispose of the suit itself is as expeditiously as possible. Accordingly, the appeal is disposed of. The trial court is directed to dispose of the suit OS number 848 of 2021 in accordance with law, not later than 1 year from the date of receipt of a copy of this order. Both the parties are directed to cooperate for early disposal. All pending applications are disposed of. Yes, Mr. Raj. Interim order idea. Interim order granted earlier is extended until next date of hearing. Yes.
Number 39, Kalyan R for appellant, Vijay Ananda.
2 weeks time may be granted to file objection.
You are appearing for
Appellant.
appellant,
Respondent has filed application.
vacating.
Vacating.
Yes, Mr. What is this?
Already interim order is granted.
Yes, learned counsel for. Now that you are for an appellant, he has filed an application for vacating.
File objection, 2 weeks time may be granted.
Yes. At the request, learned counsel for the appellant raise 2 weeks time to file an objection to IF4 of 2023. Finally, 2 weeks time is granted.
Interim order,
Interim order granted earlier is extended till next date of hearing.
please.
Number 48, number 41, Nishant AV for appellant. Number 41, Nishant AV.
On 2/8/23, I have filed a memo. The compensation that has been awarded is 36,04,601. So if I have to go before a division bench, I file the second.
Yes, learned counsel for the appellant. Finish that. The appeal is valued more than 15 lakhs. Hence, matter has to be posted before the division bench having in a roster. Office is directed to post this matter before the division bench having in a roster.
I will file the second set of papers within 1
You,
week.
before that, in the meantime, you file it.
Yes.
Yes. Then also office objection regarding the court fee.
I will.
Yes, you have to pay the court fee. Yes. In the meantime, the appellant is directed to pay the court fee and second set of the. Yes.
Written notice order I can tell us.
ಕೇವಟ್ ಹಾಕಿದ್ದೀರಾ? Let him, you appear, let him establish the case. It may dismissed at the preliminary stage. Why do you want to appear? Yes. Yes. Learned counsel, so and so learned counsel has submitted that he has filed an wakalat for respondent. 8 to 12. Office to verify and proceed further. Yes.
Number 42, Venkatesh P. Dalwai.
I see 1 week. This is second round of litigation. The appellant has given a jewelry to the IMA jewelers for repair. It was seized subsequently by the police. And subsequently, the entire matter was attached by the complainant. Found it was dismissed. That matter and my was receiving as further evidence also. That is the game. The discrepancy in the bill as well as the repair memo as well as the Caesar Mahadev which is seized by the police. R1, R2, R5 respectively. Take R1 for a moment.
No, he wants to file an objection. The matter has to be finally heard.
Yes,
This is not.
there is IES file. The reason is that why again because now they have some because the jewelry is auction. But they have not provided the trial court also. So for that reason, I sought for the not to dispose the jewelry. If it is disposed also, the details is provided to the court. And the whatever the details of auction has to be.
No. See, if they are
auction.
see, if they are auctioned, if you succeed, then they have to pay that value of the jewelry.
The details in auction is required for what value they sold.
No. Whatever value may be sold, you are entitled for the market value. Why do you worry? If they are sold less than that, we'll get that market value.
In respect of that, the detail also is required. When it was sold in auction.
See, if you prove that this is your this thing, then you have in a material, what is that measurement weight of that?
Everything is there.
They have to pay that market value. We'll direct them to pay that because
Whatever the amount they collect, they have to disperse to the provisional depositor. So at least that much, that value amount might be stored till the disposal of the subject.
no.
Because whatever amount they are collecting, they have to distribute to the depositors.
Yes.
If suppose that they collect some 10 crore rupees and deposit it, later on they say that no, we already have distributed to the depositor.
No, I will record his undertaking that if the appellant is succeed, that the respondent is liable to pay that value of that.
The point is, we have already sold these jewelries to the tune of 70 crores in the bulk. And the unit rent which is claiming for the jewelry is also in that bulk. And it also already been handed over to the subsequent bidder. And now the point is, we have filed an application before the special court seeking for the disbursement of the amount what we have received. And this is the second litigation wherein my unit rent has.
No, either when you are dispersing in respect of this disputed property,
Yes,
you undertake from the persons that.
before that only we'll finish off the matter. We'll hear the matter. It may be taken up on 17th of.
Even then,
Yes, ma'am.
you can disperse that amount to them, subject to that by undertaking or taking some guarantee. That's all. Otherwise, you have to pay it.
Later on, they will come with the say that he already dispersed it.
No, mister. If you have proved that it is your property, court will protect your right. Just because that they have sold, you cannot lose it. Either they have to record it or they have to pay from their pocket. Yes, least this matter of 2 weeks. Bharat, yen urgent illa. If they already given up, then we'll ask them to pay that amount. Yes.
It is not because a long pending issue.
No, mister. Yes, least this matter of 2 weeks.
Great.
Number 43, serial number 44, Parmeshwar and Negre for appellant, and B.C. Sitaram Rao.
Yes. Yes, mister. What is that urgency? Next week. You want to file an objection next week? Yes. Learned counsel for Aviator Press weeks time to file objection to IA 1 of 2023. Please next week. Yes.
Number 45, Arthik V for appellants.
Yes. Also,
46, Ganesh HV for appellant.
Appellant is the fourth defendant.
yes,
Suit is one for partition. Reviewed order restrains me from alienating the suit schedule property.
suit for
suit for partition.
Yes,
I am the fourth defendant, I am the subsequent purchaser.
you are a purchaser.
Yes.
Yes.
So what happens is this, there's only one schedule. The schedule comes to be allotted by the BDA in favor of a person called Arogya Swami.
Hmm.
But the sale deed comes to be executed in favor of his wife, that is Lily Mary.
Hmm.
This registered sale deed is not challenged.
Yes.
BDA is not a party. Lily Mary in turn gives it to her son. Her son in turn gives it to the wife, and the wife sells it to me. Now, Mala, the whole question is, for the purpose of a prima facie case, is the allotment presumptive or is the registered sale deed presumptive? The registered sale deed is presumptive. Lord, I have absolute title. But
No, we are not deciding on that.
we are not, yes,
Now that court said not to create third party interest.
not to create third party interest by holding that the allotment is the presumptive and the
No,
registered.
that is a prejudging that issue.
Correct.
Now that not to create third party interest for the interest of all parties. Suppose if the plaintiff succeeds tomorrow, then that third party will be that indulging in this. No, that is there. Therefore,
My submission is this, Manoj. Again, the
no,
child.
now you want to alienate that property.
No, I
Ah,
don't
then
have
why
to
do you worry?
alienate the property, but I cannot have a finding against me which goes into a pre-adjudication of the.
That we will clarify.
Huh.
That will clarify that any finding given, it will not, trial court not influencing when deciding that matter finally. But till then, you should not create third party interest.
But that will amount to an allowing because this, it goes
No.
detailed into
Hmm.
how it flows, what is the share.
No, that will clarify that. Even we can say that the trial court has prejudged the issues. It cannot be. Then this finding is not applicable when deciding that final decision.
Correct.
Yes, we can dispose of that.
What is would be?
No, that we are not allowing that. We are saying by interim order will be continued. Finding only that it cannot be influenced for the trial court to decide without influencing any finding. Trial court has to decide that matter afresh in accordance with law.
Other reason why I find this this order to be is because they did not argue the matter at all. And yet the court goes into this, your
No,
lordship will find it.
No, that is true. That all finding cannot be, even if they are argued also. That is not, the court has to see that when suit for partition, this is the suit scheduled property. Then if you alienate, it will create third party interest, therefore they can destroy. Therefore, when there is an less pendency, therefore court can exercise the power saying that you cannot alienate.
Therefore, to pass an order like this is wrong as my submission, that to pre-adjudicate everything.
That we can clarify without by affecting your interest.
My interest remains.
Yes. Well. This appeal is filed by defendant number 4. Under Art 43, Rule 1R, challenging order dated 20th June 2023 by 13th Additional City Civil and Session Judge Bangalore in OS number 26132 of 2021 on IA
I'm challenging IA1.
IA1 filed under Order 39, Rule 1 and 2. The plaintiff for the convenience, parties are referred to the ranking as per the trial court. Plaintiff has filed in a suit for partition and separate position. Along with the client, they have filed IA number 1 under Order 39, Rule 1 and 2, seeking temporary injunction to restrain the defendant from alienating the suit scheduled property, and also other IAs. The dispute before this court in this case is only in respect of order passed on IA number 1. The trial court has allowed that IA number 1 by impugn order being agreed by the same, the defendant number 4 before this court. So and so learned counsel appearing for defendant number 4 has contended that he has purchased this property from the erstwhile owner of the suit schedule property, and he has been in the possession of the property. Trial court, while deciding IA number 1, has prejudged the issue in respect of the merit of the case and given a finding the same is beyond the jurisdiction of the court. He further contended that the right of the plaintiff has been protected under section 52 of Transfer of Properties Act. Yes. Properties Act. Therefore, question of allowing that IA 1 will not arise. Be that as it may, IA 1 is filed under Order 39 Rule 1 on 2, seeking temporary injunction restraining the defendant from alienating the suit schedule property. Since the very property is under dispute, the trial court is justifying restraining the defendant from alienating that property. While deciding IA number 1, trial court has given a finding regarding that validity of that sale deed and gone into the merit of the case. That is not called for. It is made clear that trial court, while deciding that suit on merit without influencing any observation made in impugn order dated 20th June 2023. With that observation, the appeal is disposed of. The injunction order granted by the trial court restraining the defendant from alienating or creating any encroachment on the suit property will be continued till disposal of the suit. Pending applications are disposed of.
Number 47, Prakash AM for appellant, connected matter, you can publish.
Rising out of the common art.
Yes.
It's taken up on Wednesday for arguments. Matter requires to be heard.
What I'm submitting is, will occupy kindly permit us to serve the notice to the councils to represent before the trial. Some of it, but if respondents are concerned, we have to seek because they are sailing with us only. We will complete that formality. Matter may be discharged without any short.
Now that in first case,
Leave to appeal has to be sought for in respect of two appeals because they were not the plaintiffs before the trial court, nor were they the applicants, but they have preferred an appeal.
no, now that he wants that to serve a notice, let him take a notice.
They can take the notice grounds to maintain the appeal. I'm just indicating them that formality has to be completed, that they will have to prefer an application seeking leave to prefer an appeal. If they are interested to prosecute the appeal, otherwise the appeal would not be
My
maintained.
submission is, we are parties to the suit, but we are not the plaintiffs. But we are sailing with the plaintiffs only. By virtue of declining an injunction order, others also suffer. Therefore, they directly pardon.
No,
It
that's,
doesn't
They are not the
mean that
applicants.
You have to seek the legal.
no, you are in a
Parties who are-
part, no, you are a party in the suit,
The party,
but you are not an applicant.
I am not an applicant.
Is it necessary? If they are
It's not
party, any
necessary.
party aggrieved can challenge.
Not any person
What
who
is
is agreed,
required?
any person who is agreed by the order granting or rejecting injunction can challenge under order 43 rule 1R. But here injunction was never sought for by them. If they have not sought for the injunction, if they did not have a grievance before the trial court, can they come and raise a grievance for the first time before this honorable court? A jurisprudence which is unheard of.
But in that, it has been filed under order 41 rule
1R.
1R. What that provision says, which is one.
It says
What
that any order passed
will
under
be-
order 39 rule 1 and 2 can be challenged by any aggrieved person before this honorable court. But now the question is, If he was himself not an applicant, he was not agreed before the trial court by making an application. He never sought for any relief. Nor did he file a wakalat or any objections supporting the case of the plaintiff. Now, for the first time, he cannot come and set up a case before this honorable court as an appellant. Something is unheard of. There is no question of improving a case which was not there before the trial court.
See, it is for him to file an
Let them take the
application.
risk, my lords.
Otherwise, I will hear on merit whether it is maintainable or not.
Very well.
Because in the earlier round of litigation, we are parties in MFA. Matter was remanded to the trial court.
What that he is pointing out.
I understood, I followed what the argument of my learned friend.
Yes.
I sufficiently, we could be able to demonstrate that the defendant before the trial court, where the leave is required, where we are not parties to the proceeding, then we are to seek the leave. We are the parties to the proceeding. We are signing with the plaintiff. Because before the trial court, we are shown as a defendant. It doesn't mean that we are not agreeing.
No,
It
see,
is established that.
both of them argue on that point. I will decide.
Very well.
Lords, just ask this matter, my lords, if they have to complete the service, let them take a week's time.
No. Yeah, it is a second point. May,
Correct, then why would we argue with
Yes,
the-
that's
There would not be any defect on that.
yes. When do you want?
21st.
Any thought about it?
Yes, Wednesday.
16th.
16th or 17th.
17th, my lords, I'm in Harvard.
Yes.
It's a special time.
Then 21st.
21st, your lords, may have it at 2:30, my lords, so that this
Not
matter
2:30.
may take some time.
No, that regular. We'll see.
Very well, my lords. When
Yes.
the matter reaches, we are before. Lords.
Yes.
Half day of the 18th, my lord. 21st, kid, 21st.
First, may not, it would be appropriate.
21st.
21st.
First, let it be.
Yes.
Matter could be heard, it will be kindly recorded. Matter could be on merit.
No, that all matters which is in that board I have to hear. It is not that any special. This
So
one.
far as notice process is concerned, but not the case.
Yes.
Survey
No, that-
comes on the council.
no,
will
that-
appear before the trial.
Yes, each case you have to tell whom you have to take in a council and who is, in which case,
They can file a memo, my lords, to that effect, so that your lordships can record it.
yes,
Better to, for them to put it in writing.
They kindly pass it over.
Lords.
to the idea.
yes, pass out.
Please.
48. Petitioner Prasad PS.
ಏನಪ್ಪ ನಿಮ್ ಲಾಯರ್ ಇಲ್ಲ ನೆಕ್ಸ್ಟ್ ವೀಕ್ You verify from your client whether she is working. Now she is not working. Yes, Thursday. Yes, sir. 18. One time. What order copy? What order copy, mister? There is no any order. Company has not produced directly produced to the. Which, who's whether you are appearing in the company or he is working in that company? Nim company though. Now, let us see it is in the sealed cover. We'll see on that. Yes. Yes. No, it is not that. It is for the court. We'll see on that day. Yes. What is that? Yes. Leads this match. 22nd. Yes.
Siddharth been returned.
Yes.
transport which has been ordered by the husband. Those have been ordered by the. For the. That is, for this one number one, that is like car. Number two, there is the children.
Yes.
Kindly the findings.
What is he?
He manages 2 floors hotel near the would be material lodge.
He is running the hotel.
It's not it's just a lodge. It's a very. So there's
ಆಯ್ತು ರೀ, 10,000 ರೂಪಾಯಿ ಆರ್ಡರ್ ಮಾಡಿದಾರೆ ಅಷ್ಟೇ. ರೆಸ್ಪಾಂಡೆಂಟ್ ಇಸ್ ಪೇ ಮಂತ್ಲಿ ಮೇಂಟೆನೆನ್ಸ್ 10,000 to the petitioner number 1.
Arrive at the conclusion kindly one second. Para 26 would be advisable.
26. Yes.
Further context of the petition number 1 is that he required monthly maintenance of. Substantiate income of the respondent. The petition number 1 has not placed any documentary evidence. But the fact remains the respondent number. Now they are staying together. Whether it is repeated fact that the respondent own lodge is consists of petition raised huge loan for credit cooperative society limited and has taken loans of rupees 52 lakhs and is now he is going to pay the monthly installments. And moreover, he had no business out of his lodge, but repeatedly the respondent is having the lodge in his name, which consists of 14 rooms, and said lodge is situated. By part of the one. So it is learned to note that petitioner has not produced any documentary evidence to show that he has raised such a huge loan.
ಆಯ್ತು, ನೀವು ಮನೆ ಎಲ್ಲ ಮಾಡ್ಕೊಟ್ಟಿದ್ದೀರಾ ಸರಿ.
Have you taken care of their education expenses?
ಎಜುಕೇಶನ್ ಊಟಕ್ಕೆ ಮನೆ ನೀವು ಬಂಗ್ಲೆ ಕೊಟ್ರೆ ಏನ್ ಪ್ರಯೋಜನ? ಯು ಆರ್ ನಾಟ್ ಪ್ರೊವೈಡಿಂಗ್ ದ ಫುಡ್. ಊಟಕ್ಕೆ ಬೇಕಲ್ಲ ಫಸ್ಟ್. ಇಸ್ ಇಟ್ ನಾಟ್?
Best is that your lords, if collectively some of these 10,000 to be ordered. We to pay that your lords.
15,000 ಮಾಡಿದಾರಾ?
Also 10,000 to petitioner number 1, that is why, and 5,000 to the.
ಎಷ್ಟು ಒಬ್ರು ಒಂದೇ ಮಗುನ? 5,000 ಈಚ್ ಟು ದ ಪಿಟಿಷನರ್ ನಂಬರ್ 2 and 3. ಅಲ್ಲಿಗೆ ನೀವು 20,000 ಕೊಡ್ಬೇಕು.
Taking the responsibility. That's what is.
Have you paid that arrears? ಎಷ್ಟಿದೆ? Issue notice, serial number ಎಷ್ಟಿದೆ? Issue notice. Day of order dated 25th January 2023, passed by Family Court Udupi in criminal miscellaneous case number 123 of 2021. Subject to petitioner pay all arrears of amount and continues to pay monthly maintenance 7,000 to wife, that is first petitioner, wife first petitioner,
Also.
and 3,000 each to petitioner number 2 and 3. Every month. Subject to pay that arrears within 2 weeks from today. And he has directed to continuously pay that monthly maintenance of rupees 7,000 to that wife first petitioner, 3,000 each to petitioner number 2 and 3. Next step.
Petitioner.
It's an honor loan. Is it the banking money and loans or? But it is also observed in the. Pay some of 20,000, not the need.
Where is that observation that she has left that also?
He has checked in my. There is a case registered against the respondent and Lados.
What is he? What is he now?
He is running a electrical repair shop. He is selling only the bulbs and the plugs and so his income she has not.
Yes, have you paid that arrears?
No, yes, just a- The case number 74. Number 16, some fifth line here.
Yes.
It is also not in dispute that on 17/8/21, in the house of the respondent, some incident, respondent is a petitioner. Some incident took place between the family members of the respondent. 8/21 and 6. Lost his. Against. One 49, those will come and attack this.
Our decision notice.
And then-
Stay up. Order dated 6th June 2023. Passed by Family Court Mangalore in criminal miscellaneous 33 of 2021 subject to. Petitioner continues to pay 5,000 each per month to that. Wife.
3,000.
ಎಷ್ಟು ಮಾಡಿದ್ದಾರೆ ವೈಫಿಗೆ ಎಷ್ಟು ಮಕ್ಕಳಿಗೆ
20,000.
each
He
from that
has income only 10 to 15,000 years. Pay
Five-
rent, their maintenance of his.
5,000 each. That petitioner number 1 and 2. Petitioner number 1 and 2 ಅಲ್ಲ respondent number 1 and 2.
5 and 3,000.
Respondent number 1 and 2 hearing. Now 5,000 each you pay. Yes, 50%.
Parents are the age, parents are the.
Let us sing that. Yes.
Petitioner.
Yes, madam. Password, you are next week. At the request of counsel for the petitioner, leave this matter. 2 weeks. Yes, 2 weeks. Yes. 2 weeks it will come. Yes.
Petitioner. Yes, Rajshekar.
Password. Yes. Next week. Yes. At the request of the parties, leave this matter next week.
Number 53, number 54, A.N. Gangadharayamma, Petitioner, Radha R.
Yes, what is this matter? Eviction petition. You are a tenant. You are the tenant. You are disputing his ownership. Yes. Leave this matter after 2 weeks. Nobody is there for, yes.
55, Gita Devi, appellant, Nataraja Ballal.
Senior lecturer.
Password. Yes.
Date.
Yes. Leave this matter next week.
Reddy for appellant, Silpa Shah.
Yes. 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 What is that compensation awarded when it is acquired? When it is acquired, give the facts.
That is the absolute total of the land. Survey number 31 was for measuring the limit and survey number 32. Stated as Ruben and Naragali, Jigur, Obri, Vindu, Sotalo. That is converted for another ticket. In 1963. Deputy Commissioner Bengal District Bengal Secretary was earlier included in the
The land acquisition officer has market value of 45. ಆಮೇಲೆ
reference 75 rupees.
reference code to 75 ಮಾಡಿದ್ರಾ?
75 rupees.
Now you are seeking further enhancement.
Further enhancement.
On what?
Same property, property get 200 rupees ಕೊಟ್ಟಿದ್ದಾರೆ.
ಎಲ್ಲಿ?
ಕೊಟ್ಟಿದ್ದೀನಿ.
ಎಲ್ಲಿದೆ? ತೋರ್ಸ್ರಿ. ಕೊಟ್ಟಿದ್ದೀನಿ ಅಂತ ಏನು ಇದಕ್ಕೆ?
ಏನು ಬಂದಿದೆ?
Where is that? This is the case number. Yes.
ಇದಾಗಿದೆ. ಪಕ್ಕದ ಇದ್ರಲ್ಲಿ ನಿಮಗೆ 200 rupees free ಕೊಟ್ಟಿದ್ದಾರೆ ಮಾಡಿ. ಅದರಿಂದ ನಾನು ಅದೇ ಪ್ರಕಾರ ನಾನು ಕೊಡಿ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು
Same notification.
same notification.
Same notification.
150 rupees. Announcement ಇದಕ್ಕೆ ಇದಾದ್ರೆ ನಾನು ಕೊಡ್ತೀವಿ compulsory.
What you say about the 200 rupees now that announced by that? Is it, madam, it is a. Yes. 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 No, this property is when is acquired. What is issued on to award? Right, 1905.
Notification. 28/11/96. Adjoining village. Different villages are adjoining. Same for the purpose of same purpose. They will apply for that.
Yes. This is 1995. That this has been acquired when that judgment which you are relying now.
That is also 95.
Where is that, Mr.? Is 7.
Page number 9. Then of the judgment.
5. Which is that village? Karnataka, situated in Bommanhalli, Begur Hobli, Bengaluru. Bommanhalli Municipal Council. Your property is situated where? Rupana Agrahara village, Begur Hobuli, Vendur South Taluk. Begur Hobuli, Bangalore South Taluk. This is Bamunalli. No, that you can't, it is not an agriculture land, Mr. Agriculture land, even that village to village, it will not different unless there is an irrigated and dry. Here, area to area, site value is different.
The adjacent village.
Adjacent site are the Paravagilla.
Adjacent village.
Adjacent village.
Adjacent village.
Adjacent village.
Village.
That is true, Mr.
Purpose is same. Notification is the same.
But value is
President
different.
of the national highway.
Value has to be seen now.
Value also same.
Here,
The property is situated.
45 per square feet extended to the land acquired method, so on, so. Here also your officer has fixed 45 rupees per square feet.
Earlier also.
Wait, Mr. Madam, land acquisition officer, in respect of Bomanalli, he has fixed 45 rupees per square feet. Copy ಕೊಟ್ಟಿಲ್ವಾ ನಿಮಗೆ? You serve a copy. Similar property, because here also land acquisition officer has assessed 45 rupees per square feet. That has been enhanced by 200 rupees.
That case, then maybe you have to check this property.
No.
Yeah.
No. I am not at the enhancement. To make it as a similar property, your land acquisition officer has assessed 45 rupees. Also acquired maybe 1 month difference. Yes. This is also 95. That is also 95. Yes. In fact, this is earlier. This is earlier reference. Now that it is that is yes. No, not like. Madam, all pending cases, any changes of law, any subsequent events can be considered, not disposed cases. Pending cases can be considered. There is no bar.
Yeah.
Yes. Not that day. That judge who has not properly applied mind, that is their case. Now I have to see. See, when that, have you challenged that which is that passed in that connected matter? If you are accepted, you are not challenged, you have accepted that it is almost similar property. You can't deny that to similarly situated persons. You are taking up the properties of the citizens and can't deny that you will pay for 45 for one. That is not that. Yes. Not, see, you show me in connected matter whether that land is converted. It is not connected. He has produced that documents. You have to answer that. What is the difference between these two? Unless you saying that notification is different. What is that I will consider. Yes, that will consider. That I will consider. Now that, is there any other difference? Because your officer, when giving an award, passing an award, it has been fixed 45 rupees for this also, 45 rupees for this also. How can you differentiate? Wait, mister. Yes. No, that court can consider not only that what is the rate has to be considered on the basis of that other documents. Rate will not be available. It is not that adjacent land, adjacent property, or that adjacent judgment which is passed, all can be looked into. Yes. No, it's an appeal. He can file it by Order 41 Rule 27. It can be. We can entertain. There is no problem in that. Since if you are challenged that order, then it's different. We are not challenged even before High Court. You have accepted that. Hmm. Which one? Hmm. Hmm.
Register value in 50%, national way 50%. Enhancement ಕೊಡ್ಬೋದು ಅನ್ನೋದಕ್ಕೆ ಅದು ತೋರಿಸೋದಕ್ಕೆ ಜಡ್ಜ್ಮೆಂಟ್ ಆಗಿದ್ದೇನೆ ಅಷ್ಟೇ. ಅದು ಬೇರೆ ಇದೇನಿಲ್ಲ.
Wait, Mr. This is also acquired for the purpose of that national. Special Land Acquisition Officer, National Highway. This is no, that is. This is acquired under similar provision of law or a different provision of law. You are not in made as in a party, then you could have challenged that if you are an interested person. In fact, here he has made you as in a party. No, ultimately you have to pay that amount in both the cases. Is it not? If you are not a party, if you are taken an enhancement, it is a good ground for you to challenge. You are not challenged, you are accepted. Now you can't say that here. Yes. That will not make any difference.
Here also special land acquisition is the party, executive engineer is the party.
Yes.
In my case also, in both the executive engineer and this one, executive engineer is the benefit.
Special Land Acquisition Officer, National Highway. Special Land Acquisition of National Highway, Executive Engineer.
National is the
Executive Engineer, Bangalore. National Highway. Yes, ಅದರಲ್ಲೂ ನ್ಯಾಷನಲ್ ಹೈವೇನೆ, ಅದರಲ್ಲಿ ನೀವು ಅಪೀರ್ ಆಗಿಲ್ಲ, ಗವರ್ಮೆಂಟ್ ನವರೇ ನೋಟಿಸ್ ತಗೊಂಡು ಮಾಡಿದ್ದಾರೆ. ಯು ಹ್ಯಾವ್ ನಾಟ್ ಚಾಲೆಂಜ್ ದಟ್ ಆಲ್ಸೋ. 238 same Special Land Acquisition Officer, National Highway has been represented by government advocate. ಎಲ್ಲಿದೆ? No, that you are not necessary party there. Land acquired by that government. Government has to pay the compensation.
Executive engineer is the beneficiary.
In the connected matter, you have not been made as a party. You have no grievance at all. You have no. This is also for the same purpose. No, you have not challenged. See, in that case, you have a very good ground that you are a beneficiary. You are not made as in a party, but you have paid that amount. You can't choose. You are paying that amount to that farmers who have come forward to you, and you are not doing that. This is an attitude of your office. Yes. Where is that IF? No. Yes. Yes. Yes, what it? Conclusions. We'll come to that point. We'll see that part. No, that 27, 1B. Yes. Yes. No, no, this court can also exercise that power. No, we are the top. Yes. 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 No, that's see that parties to the appeal shall not be entitled to produce the additional documents, whether or oral documentary in that appeal, appellant court. But if the appellant court requires any document to be produced, he can ask to produce, he can produce that. See, order 41, rule 27, only parties can file. If appellate courts requires the document to decide, he can file and saying that this document is required for the appellate court to decide. The appellate court, this is not appellate court has to request, madam. He has submitting that this document is required for the appellate court to decide that. That is what that, because the provision is, it is only appellant can file an application. He can say, these documents were there before the trial court. I have no knowledge. It is A. B is saying that this document is required for your lordship to decide this matter. That is B. Otherwise, this court cannot grant. It is 27 is only for that. Yes. Yes.
Why? So it is not the application.
Yes. Now we can direct them to produce. We can direct them to produce because this is a relevant that we can. Yeah, we can permit them by directing. That will be applied. Yes. Yes. This is that. This is that. What else that it can be? Yes. Yes. IA. Where is your application? Yeah. No, you have argued. It is for me to pass an order. You are saying that not to pass an order. Yes, you are. I will record your submission and pass an order. Yes, yes. No, what you are saying that objecting that or it can be considered and pass an order. Now that is not a question. It is a law. If you have agreed, you can challenge. But anyhow, you can say that it can be considered for enhancement. Now you say that you have sought for only 150. The prior is to for 150. Where that is permitted, under which law you can do it, obviously. You have to convince on that. I can decide anything only on that law. Otherwise, I will fix it 150 and dispose of. Let us see. Let him see. Party has to argue and convince the court and law. If they are convinced on law, I am bound by that. Yes. Show me any judgment and law, Mr.
17(9) that judgment.
No. That should be a law that even if he has claimed, he has to. It is the duty of the council. Now not good. Now another liar and that.
Same idರಲ್ಲಿ 79 cases, 426. That of air compensation to the landowners who had not approached court, covered under the section.
Okay, other 28A, it's different, Mr. If he has not approached the court, 28A application. That's you produce that citation.
Next week.
Yes. Yes, Learned Council for appellant praise week's time. Lead this matter next week.
For appellant, HL Pradeep Kumar.
Yes. Next time, at the request of council for appellant, lead this matter next week.
57 buttons. 57.
58
and 57.
Milords for the appellants in this matter, Milords. Serial number 58 for the appellants in this matter.
Yes.
I'm ready for arguments, Milords.
Yes. Yes, argue that.
Milords, this pertains to this suit is this the appeal has been filed against the impugned order at annexure A, page number 10,
Yes.
my lords.
Yes,
That is passed under order 38, rule 5
yes,
for attachment before judgment, my lords.
yes.
My lords, the fact of the matter is that it is a suit for recovery which has been filed by the respondent.
Yes.
The agreement was there. There was an agreement which said that the period of agreement was for 2001-2008 to 31-12-2012 for a period
Suit
of
for?
5 years.
Suit
And for
for
the appellant, I'm suit for recovery of rent, my lords.
recovery of rent.
Suit for recovery of rent. There was an agreement which was there for the period 1-1-2008 to 31-12-2012. And the respondent prematurely left the agreement and also the premises on 30/4/2010. As a result of which, my lords, they had given 25,50,000 rupees as security deposit and also the same alike amount for the rent.
Yes.
So the unadjusted rent as well as the security deposit, they sought for the recovery. Along with that, they also filed an application under order 38 rule 5 for attachment before judgment. And the order came to be passed at annexure A, my lords. My lords, if I can come at annexure A, page number 4, my lords. The findings.
Now that this order is stayed.
Yes, my lords, this order is stayed, my lords.
Now, what is that stage of the suit?
My lords, it's a defendant's evidence, my lords.
Let this order be continued. Let the suit be disposed of from 2013. Order
Yes.
that impugn order has been stayed. It is that now what?
No, my lords, in fact, my lords, my submission is this might be taken up. The reason that is on a account where with regard to the security deposit and also the unadjusted rent. Now, by this suit, by this IA, what has happened is, of course, it is stayed, no doubt about it. The fact of the matter is this is a trust which has been existing for more than 10-15 years. And this order is like, I mean, we have nothing to dispose of and go anywhere else for that matter. So I'm just expecting this matter to be taken up. In fact, 2 times the argument so agide opposite Barlila or
Let that interim order be continued. Let the suit may be disposed of. You want to pending the suit for another.
No, suit is that is going on, my lords. The suit, the trial court proceedings have been continuing. The trial court proceedings have been continuing in this matter. I'll leave it to my lords. If this is only on the order with regard to 38 rule 5 only. Attachment before judgment ashtak matra simitvagiruvantadu. The whole suit is not stayed.
Wait, mister. She is arguing. Yes, wait. No, madam. All this is a merit. So now that interim order passed by this court is operating from last 12 years, let it be continue. Let's. No, that is what that injunction is also saying. See, appellant plaintiff partly allowed the defendant to direct the furnish the security to the extent of claim. In the event if it is failed to furnish, then application of schedule should not be attached before the judgment. Now that this court has passed, what is that interim order? Or attachment? What is that interim order? I do. Interim order of stay granted earlier. Interim order is extended. Granted earlier is extended. Issue notice stay period 8 weeks. Yes, Mr. You furnish the security.
My lords,
You furnish the security. Surety of that this thing amount. Then I will directed not to attach that property.
no, my lords, there is already a stay on this attachment, my lords.
No, that is attachment. Now we are hearing finally.
Yes, my lords.
Security to that extent of that suit claim.
No, Malas, I
What
will-
is that claim amount?
Miss, I will just argue if I may be allowed to argue, my lords.
How much, madam? I am asking. 33 lakhs he given a
My lords,
surety.
my lords, if I may be allowed to argue, my lords. The only simple point is, my lords.
No, you want to argue
Yeah.
on the merit, you argue. Yes, we hear that. Yes,
My lords, page number 4, my lords.
yes.
The annexure A, page
Yes.
number 13, my lords, if I may be
Yes.
allowed to read. My lords, para number 10, my lords, if I may allow to be read.
Yes.
At the same time, it is seen that the plaintiff has not specifically placed any material to show that the defendant has made attempts to alienate the suit to any person. There is also no plea in the application filed by the plaintiff that apart from the suit property, the defendant does not own any other property or source to satisfy the suit claim in the event of decree. Further, my lords, para number 11, my lords. Therefore, in my opinion, the defendant, since has not specifically disputed having received the security deposit amount from the plaintiff, is under an obligation to at least provide security to the extent of the suit claim at this stage. My lords, that may be noted, my lords. The question whether the plaintiff is entitled for the recovery of the said deposit amount or not is a different question which has to be determined at the conclusion of the trial. But at this stage, in my opinion, in the event of a decree in the favor of the plaintiff, the decree should not remain as a paper decree. And as such, there is no harm in directing the respondent to furnish security to the extent of the suit claim. Then point para number 12, my lords. Therefore, from the perusal of the materials on record, I am of the opinion there is a prima facie material on record to grant some interim order, my lords. Kindly be noted.
Yes.
He records that some interim order needs to be given. Though the attachment of the property through the apartment question, if not in the event the suit is decreed, the plaintiff may not be in a position to recover the suit claim without considerable delay. Hence, I am of the opinion that the plaintiff has made out a prima facie case and the balance of convenience is in favor of the plaintiff. Therefore, I am the further opinion that an order could be passed directing the defendant to furnish security to the extent of the suit claim. Well, the point here is, the trial court judge is gone on to say that some order needs to be given. The reason why this is, my lords, page number, my lords, the application which has been filed by them on page number 27 of my petition, my lords, my application. That's the affidavit in connection with the application which has been made, my lords. Page number 27, if I may be allowed to read. Para number 2, my lords.
Yes.
I do solemnly affirm and state on oath the plaintiff company has taken application property on lease and the same was terminated, and now defendant trust has failed to pay the advance amount paid to the defendant trust, which is refundable deposit after taking back the possession from the plaintiff to give the same to some other entity. In spite of giving many requests orally and in writing, defendant is taking an evasive stand merely to deprive the legitimate right of the refund of the amount paid through the check, which is reflected in the bank statement of the plaintiff. Hence, plaintiff was constrained to file the above application, my lords. Now, my lords, para number 3, very important. The defendant trust is situated at Bangalore and they are likely to dispose of the same to the third party merely to deprive the legal demands of the plaintiff company Hence, it is just to attach the application schedule property till the disposal of the suit, so that the money can be recovered. Now, my lords, apart from making this allegation, nothing and record has been brought by the defendant there to say that the efforts have been made to dispose of the property. The act of the defendant trust may be deprived the legitimate right of the plaintiff of the company, even if the decree is passed in their favor. This is much has been written, my lords. Now, in my lords, page number 37 of my application, in my petition, I have also filed my objection statement. If I may read, that is the objection statement to whatever has been the application filed by the defendant in this matter. If I may be allowed to read page number 37, my lords, annexure E.
Yes.
My lords, para number 2, the last part of the sentence, there is a condition in the lease agreement that no termination of the lease till the expiry of the 5 years. The allegations in para 3 of the plaintiff affidavit that the defendants are likely to dispose of the same to third persons to deprive the legal demands of the company is absolutely false. We have denied it, in fact, my lords. It is only concoction of the purpose of this application only. And para number 5 also, we have specifically told that defendant submit and respect the defendant is a charitable trust. The scheduled property was allotted by the Mysore Urban Development Authority on lease basis.
Where
The
is that,
total cost
plaint-
of,
plaint-
my lords,
Now, where is the plaint?
para page number 16, my lords. Page number 16, the plaint has been annexed to, my lords, annexure B.
Yes.
My lords, this is the plaint which has been filed by the.
So they are using that word, suit scheduled property, suit scheduled property. Where is that suit scheduled? See the suit scheduled property. In all
That's-
applications are there saying that they are alienating the suit scheduled property. You will not alienate the suit scheduled property. Where is that?
That has not been part
There is
of
no
this.
any schedule. into
There is
the
no
suit.
suit schedule property, my lords.
Then all that both are pleading like that.
My lords, and further, my lords, my contention is that
Where you have stated? Yes.
my lords, my submission is
That whether you have violated the term of the lease or he is violated, everything has to be decided in the suit. We will restrain him. He will wait, madam. I'm not deciding that lease agreement here. It is only now that we will restrain him to not to alienate that property premises which is under dispute till the disposal of the suit. We will direct the trial court to dispose of the suit. Your right has been protected. If you succeed, you can the attachment of that property. If your property is sold to somebody else, then only your problem will arise. That is your allegation in that application also. Now we will protect that. Instead of depositing that amount, we will say not to alienate that property. Oh, let him take. It is his property. Why do you worry? You want that your return of money only if you succeed. That it has to be protected till then. We will say that not to alienate. You can say that not to lease out the property. Keep it that property like that one. It cannot. Yes, that's why I'm searching. Where is that scheduled in respect of the premises? What is the premises? Which is the premises? On these.
the premises is the very same premises where they were on lease, my lords. The very same premises which.
No, I want to mention that not to alienate this premises. Premises means that address should be there. Huh? 25. In the application you have mentioned. Scheduled in that application, not in the suit.
My lords, that is not been mentioned in the suit. It is only in the application for 38 rule 5, my lords.
No, now I will restrain you to alienate that property. Till
My lords,
disposal.
my lords, my prayer.
That is
before
your
my lords.
affidavit. That is your affidavit. You said that we are not alienating.
No, we will, my lords, it's more than 10, 15, my lords, this is a trust which has been existing from very long time. In fact, we are not on that point, my lords. We are not even going to alienate because it is our property. That is point number one. We have only given them on lease. My point, my lords, is with respect to this application, whatever they have filed, the finding of the very judge is very specific that there is no such intention of giving it for any other purpose, and still he has written that at least to provide some security, my lords. My lords, therefore, I have provided 2 judgments also for your lordship's consideration. If that may be taken up, 2 judgments I have given, my lords. That's my submission is, if my lords could see the very tenor of the order which has been passed by the judge, specifically says there's nothing on record to show by them. In fact, para number 10, 11, 12 specifically says there's nothing on record. So therefore, it is only an application which has been made by a bald application which has been made. And in order to ensure that security, that has been done. In fact, para number 10, page number 13, my lords, is very emphatic on that. There is a finding by the judge. Para number 13. Para number 13, I'll just read. At the same time, it is seen that the plaintiff has not specifically placed any material to show that the defendant has made any attempts to alienate the suit scheduled property to any person. Having said that, Order 38 Rule 5 has been passed. There is no plea in the application filed by the plaintiff, as my lords saw in the application also. Apart from the suit scheduled property, the defendant does not own any other. So therefore, my lords, it's only in bald application which has been filed only in the apprehension. Mere apprehension does not give rise to 38 Rule 5 is my argument. And my lords, I have also provided, sorry, my lords, I have also provided 2 judgments before, 2 judgments for your consideration. I have provided as a compilation, my lords. On 17/8/2021, I have provided the compilation. ILR 2012 Karnataka 3328. Now, my lords, if I may, there are 2 judgments of the High Court and also one of the Supreme Court. My lords, this first judgment is by the Karnataka High Court, ILR 2012 KR 3328, my lords. Lords, in a similar situation where the court has found, if I may read out the applicable provisions only, my lords. Page number 19 of my compilation, my lords. Page number 19 of my compilation, para number 17, my lords, if my lords got it. From the aforesaid decisions, it is clear. From the aforesaid decisions, it is clear that the object of 38 Rule 5 is to prevent the decree that may be passed from being rendered infructuous. The power of Order 38 Rule 5 should be exercised sparingly and with utmost caution. Otherwise, it may become instrument of oppression. It's a drastic power which may not be granted on a mere assertion by the plaintiff that the defendant is attempting to dispose of whole or part of his property or remove whole or any of his property from the jurisdiction of the court. Simply production of the language used in Order 38 Rule 5 will not meet the requirements for grant of an order of attachment before judgment, as is the case in our case also, my lords. The affidavit must state the source of the information or even the apprehension. Before exercising power under this rule, the court should be satisfied that there is a reasonable chance of decree being passed in the suit against the defendant. This would mean that the court should be satisfied that the plaintiff has a prima facie case, my lords. My lords, if I go further, if the averments made in the plaint and the documents produced in support of it do not satisfy the court about the existence of a prima facie case, the court will not go to the next stage of examining whether the interests of the plaintiff should be protected by exercising power under Order 38 Rule 5. Further, my lords, the purpose of Order 38 Rule 5 is not to convert an unsecured debt into a secured debt. Now, that's what they're trying to do, my lords. That's what they're trying to do. Further, my lords, any attempt by the plaintiff to utilize the said provisions as a leverage for coercing the defendant to settle the suit claim should be discouraged. where a small portion of the property belonging to the defendant is being disposed of, no inference can be drawn in the absence of other circumstances. That is it. The court would not be justified in issuing an order of attachment before judgment merely because it thinks that no harm would be done thereby, or the defendant would not be prejudiced. The court should also bear in mind any attachment order passed without complying Rule 1 is void. If the court, in spite of the rule, sub-rule 4, passes an order in a casual manner, such order must be struck down. Now, this is what I am asking for, my lords. If my lords can see the application.
No, attachment, the prior and relief for the attachment will not be survived. We are not granting that. See, attachment of the properties is affecting the right of the parties. Therefore, court has held that should not be on the apprehension. We are saying that we are modifying and to say that not to alienate.
No, my lords,
what you said is correct. Attachment, when there is no apprehension for alienating that property, there is no material has been shown. It is not that attachment of the property means taking over right from the property. Here we are not saying that. We are saying that you should not alienate. We are holding the relief. Yes.
My lords, I agree on that point, my lords. My main point is, my lords, even in modifying the order also, it would be not in the interest. The reason is simple, my lords. It is my property. It is I am the lessor of the property. I can at the most give it on lease. In fact, this is a matter which I have specifically stated also, that we do not have any intention of selling the property. When that is the case.
We are also saying he is not intention to alienate, therefore not to alienate. That's all.
No, my lords, that is I am only praying before this honorable court. Let such an order not be passed. The reason is, my lords, this very application is only one applicability of Order 38 Rule 5, which we are arguing for, my lords. That's my submission. That's only my submission, because
yes, I take note of your submission. Yes,
they are trying to move it in such a way that they want to sell off property for the purpose of obtaining this money, which is actually not correct also, because they themselves in the merits of the matter, my lords, if it's in the merits of the matter, they have prematurely left the property and went off. That was the trigger reason for them to go and ask for the money. Otherwise, to file the suit for recovery.
No,
otherwise,
if you have make out in a case, it will be dismissed. It will not affect your rights. That has to be decided by the trial court. I can't decide.
I agreed, my lords. My submission, my lords, this very application is for Order 38 Rule 5.
Yes,
so
I understood that.
Yeah.
It's your case, yes. What you say, madam? That's mere apprehension, it cannot be attached. Property cannot be attached. That is what that. No, you are not on that. Your application under Order 30. No, withheld. No, withheld. It is for you to seek any different relief. You have filed an application under 38. 38 for attachment of the property. Attachment of the property can be done only if there is an apprehension is, defrauding that by court, also by alienating the property. There is no such situation. Even you have not pleaded that he is going to alienate. They have not stated that we are going to. They are saying that there is no pleading that we are going to alienate. That is what he has pleaded. Nothing has been observed. He has said that there is no apprehension, there is no necessity. Still, he said that it has to be attached. Even court could have been paused to advise you to file in a better application instead of that under Order 38. Now, what is your answer for this judgment?
My lords, one more judgment, my lords, if I may be just to, there's one more judgment, 2008 to Supreme Court cases.
Court has, no, see, court has made up a mind. Then by staying this, it is affect your right. You should have been ready. He is not affecting that. He has an absolute interim order from this court. Yes. You very answer that question. Yes. Not tomorrow, next week. Should be ready, madam. You should not. You see advocacy, how we used to do it. Not only searching the judgment in my favor, we are searching the judgment which is against us, and we should be get ready how to distinguish. That is how we have to be ready. Judgment which is ready in your favor, if you are get ready, that is no use. we have to anticipate that other side is going to cite this judgment. How I have to distinguish next week?
Much
Yes,
obliged.
next week, next Thursday. Yes.
Much
Interim
obliged.
order is absolute. Or what do you? Yes, it's an absolute interim order. Period of 8 weeks. Yes, interim order granted earlier is extended till next date of it.
Much obliged.
Yes.
59, serial number 60 at 10, serial number 61. K.R. Anand for appellant, connected matter, Geeta Devi MP.
Also,
Serial number 62 at 10, serial number 63, Sangamesh RB for appellant, P. Prakash.
also. Yes, madam, pass on.
61, I'm sorry, my lord, 61 adjourn ಆಯ್ತಾ?
61, yes.
My apologies, my lord, my apologies.
Pass or.
ಇಲ್ಲ ನನ್ಗೆ ಅದ್ರಲ್ಲಿ ಟೈಮ್ ಬೇಕಿದೆ ಸಮಯ, ಒಂದ್ ವಾರ ಟೈಮ್ ಬೇಕಿದೆ ದಯವಿಟ್ಟು.
No, you are appearing for whom?
61 ಅಲ್ಲಿ ನಾನು KR Anand for the appellant.
Yes, what is this matter, Mr.? There are
261.4.
why it is 2016 matter.
ಒಂದೇ ಒಂದ್ ವಾರ ದಯವಿಟ್ಟು ಸರ್, ದಯಮಾಡಿ ಒಂದ್ ವಾರ.
Yes, at the request of counsel for the appellant. 61. We read this matter next week. Yes.
Obliged, grateful, my lord.
Serial number 62 at 10, serial number 63, Sangamesh RB for appellant, T. Prakash.
Ready. But. Sir. Sir. You said, I thought that you are ready. He wants to take a time. Now you are saying, yes. Passer. Yes.
A. Keshava Bhatt for appellant, Anil MH.
Passer. Yes, passer.
Serial number 65, R. Deshpande for appellant, Sarati.
Why it is urgent? Oh, another connected matter. Time was, yes, pass over, let him come.
They should take out salad and this to be served for the attack.
Now that which respondent in which case
I have furnished the already.
notebook. Yes. Yeah, 16. Yes, leave this matter on 16. Oh, yes, Mr. All that railways matter, they are saying that you have taken over and nobody is coming for that.
You not fit my direct office to take my name, my lord, that I be present because now this the railways litigation is taken.
No, there's advocates saying that they have written everything to that railways. They have to respond immediately or entrusted the matter to one of the council. Somewhere see serial number 10. Non-compliance of office objection. They are saying that file is not with us. Nobody is coming there. It is actually your duty to entrust the matter to that some council. They have to file an wakala.
What is happening is that they are not the railways.
Yes.
Those files have not been returned. Therefore, that we are facing. In the new matters, we are getting the files.
No, otherwise you have to either you have to say old matter, let them continue, or they have to instruct them to return forthwith. Otherwise, this will ultimately we are facing the problem in between you two.
You are not a direct office to show my name, I get that, you get the
Yes.
record.
Yes. Ali, V.K. Narayan Swamy office is directed to show the name of Assistant Solicitor General for applying. Delete the name of V.K. Narayan Swamy.
Shanti Bhushan, Assistant Solicitor.
Shanti Bhushan, yes. Directed to show the name of Shanti Bhushan, Assistant Solicitor General. Yes. Yes, we'll see. We'll see when the discourse. Yes.
Sorry for that.
Call matter, list number 1, serial number 2, R.A. Devanand for petitioner. I apologize.
Yes. Yeah, this is the way where kind of an office and a relationship. But then he's something for it's good that is very good to one office for it to get a TPS format and you got solved by the format. It's still a little possible to achieve it. You are why it is two levels. Both are possible open door and you have to go. I'm like, simply because it depends on future promotions that are
Is there any bar for giving a surety under which company?
Then they came up with that was the matter. That was I do not have to. You go for the industry, the school back at the body. That office is the
No, you want to execute what?
Terminal benefits.
No, but that executing court, how they will get a jurisdiction?
No, exactly, under the CPC, they are right. Now, that finally, under the industry, there was an officer designated. Other than going to the police scheme.
Yes.
Office abolished.
What is the office objection?
Check what is check. Okay, out of that 70 lakhs.
Yes. Now that what is the office objection? Plain copy of the execution petition to be filed to verify the fact of.
Then I requested the court of those actions which are filed along with the petition, he retained the CR so that it is easy for the court to make a reference and take note of it. Objections are overruled.
No, office objection is kept open, issue notice. Let us see.
Go by hand and by.
No, the issue emergent notice in addition. The petitioner is permitted to take out hand summons to respondent. Yes.
80, P. Mahesha for appellate.
Yes. Yes. Party. There is no other office objection. 25. Before trial court has not made a copy, I will consider second block 20. Yes. What is it? Yes. Yes. What is this? Yes.
Declaration that 1970 is not waiting for injunction.
Yes.
1976 for Lordship.
Yes.
My late father,
Yes.
and appliance father for Lordship,
Yes.
purchased the site for Lordship.
Yes.
And he has obtained the loan and constructed the house.
Yes.
At present, Lordship, I want to demolish the portion of the house, Lordship. I demolished. I started construction.
Yes.
By obtaining permission from the village. Even a plain case. If I receive the injunction. Produce all the documents. Without verifying any of the documents, let us see.
What are you constructing now? You have taken a plan.
It is 46 minutes.
What is the stage of construction?
But I constructed still first floor going to back. Did my construction.
That order of the train code.
That's part of it.
This one is the agent, servant, person present to me with the distance.
This 1976 said it, the findings 76 said it ಅಲ್ಲಿ ಅಮೆಟಾರ್ಗೆ aspect rates ಇರಲಿಲ್ಲ.
Yes.
I have produced the data to show that since 1936 I'm in position. My father was constructed the house.
Issue notice. Stay up. Outdated. 14 July 2023. Part in OS number 2867 of 2022 by 61st Additional City Civil and Session Judge, Bangalore, subject to condition. Further construction for the suit scheduled property is in accordance with law. In accordance with law. It is also made clear that he should not create third party interest or third party interest in the suit scheduled property till next date of hearing.
Number 45, Kartik V for appellant.
Yes. Yes, to 30. 45. Yes, Mr. Kartik. Right. Yes.
Application or 276 can be maintained by a executor.
76.
May be maintained by an executor nominated under the bill.
Yes.
The person who is trying to push him was a negative under the bill. At least in section 222 fines.
76. Correct.
Okay. Shall be granted.
Section you want to read 270?
222.
222. Yes. Probate only to be appointed the executor. Probate shall be granted only to an executor appointed by the will.
Express or implied. Okay, number 276. Petition for probate. Application for probate or for letters of participation. The application
Application district judge really, no, where it is said that only that application for a probate. Where is that? Rule?
Wait shall be granted.
Rule, ah?
222, section 1.
Yes, probate shall be granted only to the executor appointed by the will. Yes, you are the one who has been executed under the will.
Honorable Judge forgets subsection 2 of 222. It's an implication. Since I'm the only person under the legacy in this matter, I get the problem. Because my actors property. For example, the district addresses to the bill, citation has been taken, everything is done. Only on the note that will not test the executor is not there. The petitioner.
Executor appointed by the will. No, legatee can also file an this thing. There is no bar.
Yes, sir. There are two things. Suppose I have a minor son. And I execute a bill. The minor son can't file for probate. That's it. And only the execute. Maybe my wife or somebody. In cases that there is only one legatee. But decided there were 4 legatees. So in case there is only one legatee. Is at page 16, not paragraph 14.
Yes.
14, paragraph 16. Start with page 30, paragraph 14. Reading.
Yes.
The opposite provision of law transfers the transaction to granted also favor executor appointed.
Where is the will? Have you produced the copy? Produce that copy. Yes, next week. Yes. Thursday, next Thursday. Yes. Use this matter next time.
Number 63, Sangamesh RB for appellate, T. Prakash. Number 63.
Set aside miscellaneous sacrifice. It was heard in the last date of hearing. That's order 5 rule 17.
Yes.
The procedure affixed has not been followed. So therefore, in fact,
Just recollect my
Yes.
refresh my memory.
but that's fine is soon.
Yes.
Case number 413. 413.
Yes.
I am the petitioner in this case, appellant in this case is the defendant in this suit.
Yes. Suit
That
for
suit came to be the injection.
injection.
That suit came to be decreed towards expert. I was placed expert in that suit.
Yes, on
And
10/3/20.
decree was granted on 18/9/2014.
Hmm.
But when the holding that decree, when the plaintiff comes near the suit to the property, the respondent hearing comes near the property. I come to know that there is an expiry decree.
Yes.
Then parallelly, I file a suit. 4114. I don't file a parallel suit first, which is consideration to be On the other hand, notes, I file a miscellaneous petition to set aside the ex parte decree. There is a delay of 3 years. Notes, I come to know about the decree only in 2014. I file a miscellaneous. But the miscellaneous is 761 of 2014.
Yes.
But the trial court has rejected that miscellaneous. Against which I have filed this.
Yes, why dismissed?
My lords, we kindly come to para 11 of the order page 13, my lords. Running page 13.
Yes.
It's my petition filed. Good trial court.
Yes.
Para 11.
Yes.
Negative consult examined as PW1 exhibit P1, P4 are not denied by either of P5, P9 are to establish RPAD cover which show that address is as mentioned in the claim. Service. 7 years she is residing. There's no such person there. Except P10 is certified copy. Taken from paper publication and divided in spite of the paper. P11 is the Aadhaar card showing the present address of the petitioner here. It's not rightly on the address link, which also admits to be residing prior to 7 years. She also admitted that she has filed OS number 1393 for 2014 before that.
No, that you are residing in the same address.
Because I am residing in the same address. At that time, I was not residing.
Why?
Because I was not residing in the because on the date when the suit was filed, I say that in cross-examination I was residing in that address. But summons has not been served on.
No, that I will come to that point.
Yes.
Whether this is the address we are residing.
Yes.
Then where is that Prakash?
The order sheet has been. Last date I have shown that order sheet. I have produced along.
Where is the order sheet? No, that I want to see. Last time Prakash that's a order madidla. No, acknowledgement wants to see. I want to see that acknowledgement. What is that? Why it is written? No, if it is refused, it can be served. It can be permitted to take answer. No, that postal acknowledgement. The RPAD shows that address is mentioned in the plaint and that to establish the right of the petitioner is RPAD, which was shown that denied either the parties are relevant to the suit to establish the right of the parties. Exhibit P2 is the RPAD, which shows that address is mentioned in that. What is that RPAD shows? No, what is exhibit P2 another?
RPAD cover plots which they sent.
Where is that exhibit P2?
Address is as mentioned in the claim with exhibit P4. The petitioner in the process. RPAD is the RPAD cover of the case.
You have that RPAD cover is there. That is the crucial.
5/17, I read in the last paper. Can I pass on that?
Yes.
Concern the address. I will.
Yes, where is that? How it is to be served? ಅಲ್ಲ ಯಾವಾಗ ಪೇಪರ್ ಪಬ್ಲಿಕೇಶನ್ ಬರುತ್ತೆ just no you show that provision of law. Yes. Yes.
dependent refuses to accept service or cannot be found. Where the dependent is agent, such person has a person refused. Yes. There's no likelihood of his being found at the residence within a reasonable time. There is no agent employed to accept the service of someone on his behalf. Or any other person on whose service can be paid. Not this is pushing. Nor any person who is on whose the serving officer shall affix a copy of the door or some other person which is part of the dependent ordinarily resides or carries on business or personally works for him and shall then return the original to the court from which it was issued with a report. He has to prepare a report. Report endorsed thereon or annexed thereto, stating that he has affixed the copy. He has affixed the report. He has affixed the copy, the circumstances under which he did so, and the name and address of the person if by whom the house was identified and used against the copy was affixed. But this report has to be.
You come to that next Karnataka amendment. 17, where the defendant is agent or such other person opposite refuse to sign the acknowledgement, not present at the house, ordinarily residing, carrying a business, personally working for it. That is perfected on him, where the likelihood of his being found that upset the police service on behalf of his person. Again, here also affects.
A fixture procedure to they should have completed.
Yes. Endorsement time. Certain officers in their own cases.
Examination of the serving officer is 19.
What about the 20?
Satisfied that the reason to believe that defendant is ordinary way. The court should order the summons to be affixed by served by affixing a copy thereof in some conspicuous place. What is and also the defendant is known to have last decided or carried on business.
One year.
Where the court acting under some one orders which can advertise. The newspaper shall be a daily newspaper circulating in the locality. Carried on business or personally work for gain.
The court is satisfied that there is a reason to believe that defendant is keeping out of the way for the purpose of avoiding service. Paper publication can be ordered.
There has to be a finding.
That's why that is there any judgment that finding should be there?
Endorsement of the it says no such person is found. It says that no such person is found. Those should have given a finding.
Yes. Where is that order sheet?
Since there is no reason to condone the delay of 3 years.
Yes.
Application notes was active for some time. I'm saying that I had filed a parallel suit in 1393 bar 2014. 93 by me for injunction. That time saying that they now filed the written statement that suit, saying that I was aware of this litigation and they said that they will produce that written statement. They asked to produce it.
That no, in that in the written statement you have stated, or in that plaint you have stated?
Plaint also
Plaint, which is that suit filed by you?
1393 bar
1393
2014.
14. Where is the suit signed? When this miscellaneous application has been filed?
Miscellaneous is filed in 2014.
No, date.
Dated. It was filed on 23/9/2014. 9/10/2014, I don't find this.
9/10.
2014.
Then whether if your mention is nothing, it is after filing that miscellaneous you have filed that suit. Even if might have been mentioned about that dismissal, by the time you have knowledge. Therefore, it will not make any difference. It will not make any difference that we have admitted there or not, because it is after that. Yes, Mr. Even in that, if he has admitted, there is no that, because this is after filing that miscellaneous. After he has come to the knowledge only, he has filed an Or if the suit has been filed earlier, there he has mentioned about this, then things should have been different. Why the trial court has dismissed?
That was that the 3 years delay explain what the came in. I had no knowledge and then I failed.
Yes.
Honestly, it says that RP is वापस कर दिया जाएगा endorsement. Doesn't discuss about the trial court does not discuss about.
No, RP is served ಅಂತಂದ್ರೆ paper publication ಅಲ್ಲಿ ಬರ್ತದೆ. Unserved ಅಲ್ಲ. No such addressing. See, if court finds that really you are trying to avoid that, then they can ask for a paper publication. Yes, Mr. I will impose some cost and send it back. Pass out. I think.
Yeah, not serious.
Yes. Yes.
And trying to make its name is page 47, not page itself.
Yes.
Number 1 is
ಇದೆಲ್ಲ ಮಾಡೋದು ನೀವು ಇಂಗ್ಲಿಷ್ ಟು ಕನ್ನಡ ಟ್ರಾನ್ಸ್ಲೇಟ್ ಮಾಡಿ ಏನು ಗೂಗಲ್ ಅಲ್ಲಿ ನಮ್ಗೆ ಕಳಿಸಿ ಏನಿಲ್ಲ
the land number 2.
Yes.
He has signed this page.
Yes.
And my lord, as the data is concerned, in favor of so and so, 1, 2, 3, 4, page number 49.
Yes.
Page number 51.
Yes.
Last but from where, my lord.
Yes.
Whereas vendor number 2 is giving the ruler right.
Yes. Para number?
Page 51, my lord.
Yes. Yes.
Whereas the vendor number.
Yes. Yes. Yes.
Giving ruler right.
Yes.
My lord, why we purchase from the yes, we need to put multiple subgroups.
Yes.
So the purchasers wanted to be very sure that the problem on the ground.
Yes.
So it is related party and it's the left hand take my lord as usual, publish the signature with the photographs of all the parties. So that's a consideration concern. Page 53.
Yes.
Page 52 signature with the photograph and thumb impression.
Yes.
Now page 53. Ask error data. Case of paid entire consideration of 80 lakhs.
Yes.
As follows. Number 1, 49 lakh 50,000.
Yes.
By year, 10 number so and so, 2 vendor number 2.
Yes.
And 50,000 so and so, 2 vendor number 2.
Yes.
And the date 21/11/2018. Every. Check. But I was not check. I was not compare. I will not read because vendor number
18, vendor number, next page 18. C, vendor number 1, my lord.
Yes.
D, vendor number 1. D.
Yes.
Now, I again.
Yes.
Then we got C.
Yes.
The vendors will be declared and because can anybody will not now say that the digital document, but again come and say, no, I don't agree with this. And because section 91 and 90, here may not answer and may not. The digital document is without in that. That's a kind of back out from the recital melody. Vendors here may declare, consume this deed, they have completion in favor of the consumption of the luggage. Take an interest. Vendors have put the actual position.
Yes.
Observe about this day. Position entered to 200 million dollars. Market in income and section. 6 other liabilities.
Yes.
7. By virtue of this, all the rights are vested now in terms of the purchasers. And they can transfer the car tax and come out. The schedule may not be easy. Page 30% of land.
Yes.
Non-agricultural renewable property is that been converted. Converted.
Yes.
Non-agricultural land. And the this document must continue in my lord. This document is a registered document signed by the plaintiff. And wherein he has received the consideration by way of check. He cannot say not have the knowledge. This one.
Now, what is the suit for?
Suit is said as say.
Yes.
Yes, but you can there are 20 next document.
Yes.
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 Now, suit was my lord. The
Yes.
all the sellers may not and 1, 2, 3, 4, 5, 6. 5, 6 are purchasers. 96 number 7.
Yes.
This is Canada.
Yes.
Canada right first seller.
Yes.
She admits it. Share for variance. Now this person immediately changes the mulligan tenant melody. He writes it to and I will let him allow to be there. Cassidy. Of the city.
Now, why can't you file an application for rejection of claim?
My thought was only the last part of that I was studying that.
Yes.
Our of the answer is to speak with the right color in one aspect. What happens many times in this melody, what I say is you on the day it's no what.
Yes.
21. I get to
No, by reading the plain and the documents producing along with that plain, it is. No, that have you filed an application?
No, but application is not right, but this is the is predicament in this melody that I get to take my lot one sentence in the plain my lot, sir, because this one report and the was indicated in my lot, that was to be on the plain.
No, some of the judgment says plaint along with the documents produced along with the plaint can also be looked into, not that written statement. That is there. I think recent judgments are really covered. See, the intention is should not be allow for the frivolous litigations. What can yes. Even limitation, that's what I said. Now, recent judgments, even then that even limitation, it is clearly barred by reading the plaint itself, which is make out, it can be dismissed on but recent, I think.
They come to that and they cover the right to make it want to do and also when you get what my lord says, my lord, permit here that only I something that I want to do. Two.
Yes.
7. Setting legal fraudulent act of one to the legal practitioner of state to the knowledge of the in the month of March.
Yes.
He said it. He said it. Where the like that.
No, court said by clever drafting is not this thing.
Actually, I will not know. I wanted to do the same reason. I cannot do
Yes, yes.
camouflage.
Yes.
Camouflage.
Yeah.
Remove the camouflage. If I got the previous
Yes.
and I asked for the I can't say it right now.
Yes. Yes.
But the aspect of the matter may not be carried. And I will now come to see everything. There is a time to ask the question of my data. So we did not tell that I distributed it in my lot.
Yes, yes.
That may not have been. We advocate advice and times my lot. The other one decision to the again. It is an advanced stage of thinking process. Initial data is after we was my lot.
Now that it's they should have tried. Application ಹಾಕೋದಕ್ಕೆ ಏನ್ರಿ ಅದಕ್ಕೆ ಆಮೇಲೆ ಹೋದ್ರೆ ಹೈಕೋರ್ಟಿಗೆ ಬಂದ್ಬಿಟ್ಟು ಸಿ ಅವಾಗ ಏನಾಗುತ್ತೆ ಅಂದ್ರೆ ಅಲ್ಲಿಂದ ಇಲ್ಲಿಗೆ ಬರ್ಬೇಕಾದ್ರೆ ಇನ್ನೂ ಏನೋ ಲಾ ಡೆವಲಪ್ ಆಗಿದೆ. Then that lawyers who are practicing in high court, they know more than that what they can even high court can also entertain. Yes. Yes.
We cannot come out of the deep knowledge. Deep knowledge is from the data presentation result. I cannot come out of this
Yes.
data presented.
Yes.
Moreover, also we got. I resume something. I can't feel in my ignorance. You want to share. You may know, you need to tell them. You also does not get something happen. About the 19 and knowledge, thereafter also gets the right.
No, that, what about that he has signed the document, so he has not disclosed anything. Then he has signed that registration certificate, sale deed.
Oh.
That itself is a knowledge. What is that explanation for that?
He said, I don't know whether there. How did you
No, MOE, no. When you have signed the documents, it means that you have read the documents and you have understood.
Evidence and
No, tampering and all is there, then it's different. Forgery. No, even after my signature, no, that figure has been tampered, something it's different, but everything is admitted.
Yeah.
Yes. ಅಲ್ಲ ನೀನು ಅವ್ನು ಸೇರಿಸ್ಲಿ ಸೇರಿಸದೆ ಇರ್ಲಿ ಹಾಕಿ ಹಾಕ್ತಾನೆ.
Building ಆಯ್ತು, ಪರ್ಮಿಷನ್ ಆಯ್ತು, ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಆಗಿ certificate ಆಯ್ತು, ಕಂಪ್ನಿ ಸರ್ಟಿಫಿಕೇಟ್ ಆಯ್ತು. ಆದ್ರೆ ಅದು this came.
Yes.
Of this clear 22 came and we have been documents. My lord, that the airport order is servers.
Yes.
Whether it impacts my lord's kind intervention is the question, my lord, but 3 days. Refusal of application. My lord is established as the intention of the concerned. The execution order. My lord, we prepare the orders covers based on no material. Order is plausible order. That is not material. That is the established principle, my lord. The things of addition of that.
Yes. Yes. Switch for partition. Partition, huh? Yes. No, what is that relief sought in that IA? No, not to create third party interest. Is it? No, I think we sought only not to create third party interest. ಇಲ್ಲ ಮನೆ ಎಲ್ಲ ತೋರಿಸಿದ್ರು ಅವರು only that relief. Yes.
Dependence and current experience of labor taking over on them from making any kind of construction. This is
Yes.
When he comes to the road, and also my lord decision made for election because third party is a great what happened is they have obtained loans from the banks. They have put our investment into that.
What is that building you are constructing?
Building is my lord.
Apartment.
Commercial plus residential building, my lord. Multi-story building. Otherwise, you have to do.
Yes. Yes. Yes.
Commercial, you mentioned a lot of funding. From four shops, first floor shops, second floor, third floor, terrace.
Yes.
And not only this, getting the data is why you are taking it. If I you are not to get it 7 levels. That's why you play for the after challenges immediately come, otherwise third party will be created. Definitely they give you register document 127, 7 numbers, 19. What I asked him, he himself said, March is right. March 19. Register document numbers, comes and completion certificate also may not be taken. And vacancy 136. 136. So he said, March 19 comes.
Yes.
Silent in September 136. Leader declaration may not do September 19. Submitted under the act may not go to the corporation.
Yes.
That it contains pages of 138 may not. Etc. And after this is important. Page 152. Page 154.
Yes. Yes.
Declaration
Yes. Yes.
This date given because his application was dismissed on September 20. After that, my completion granted 25.
Yes.
And then my lord, page 155. And my lord, the builder has to give me cash over my lord. And the registered agreement, my lord, the builder.
Or you give some bank guarantee and proceed with that matter. Sale and all. I have not yet heard him, but instead of all this, and also I will give any liberty. If you have any grievance, you can file an application for rejection of claim. Till then, some bank guarantee to that, because writ petition has been pending before this court.
This document says an agreement for sale and consideration. This document, right? That memorandum of understanding.
Yes.
May not start with my lot of the sale and back. Memorandum of understanding or my lot of it's subject to
No, even I am not deciding his right is on that memorandum of documents or on that. Only thing is that writ petition is pending before this court.
Like what granted by government and there is with right that distinct by criminal, by other government, distinct by a then it is pending. That's my lot of word. I must take case that committee. I must take case. I must take so I have to write. I must take care of something right. I must take
No, we don't know what is that order will be passed by this court. We can't expect that this court is going to dismiss his petition.
Stop delegation. This one product stop delegation. Not that land delegation, the land becomes the land pending matter. The matter is pending since related date. Put it. Matter is pending. We try it not by right for idea.
Yeah.
Idea is between. Put it right. I want to electricity supply. I think we will commit and we got a proposition and then civil court judgment. That is not in question. See, my way. You can put that, this one, that is, by everything, this, if the other put gold, that is, yes, that, yes, you will be, yes, my lord. They can be granted. Remember, they will be granted. He cannot accept, he cannot this code because that is from this MOU. Firstly, this MOU does not take anything. Legal matter, legal matter. Not standard form. This is the understanding may not be page 43,
Yes.
200 rupees. And consideration mentioned may not take anything. Consideration 2 crores.
Yes.
And party, it party, is the party, not party. And now they may not. He is going to transfer this property.
Yes.
Property is paid for what it is. $50 lakhs paid, other uncovered lakh. I went to submit the legal one. No court can pay if you order on unstamped or insufficient stamped document. This requires kind of stamp as well. It could be.
Yes.
And the Karnataka stamp. They cannot do. I think.
If he has no right, why you have included in that sale deed?
My lord, I can include as something, but even if a person has no right at all for this reason, my lord, to avoid. This is the approach. My lord, the how can article system can say it there.
That petition is pending. Mulageni title. You yourself as recognizing him as a Mulageni tenant. You then why you have paid 50 lakhs?
Yes, I have read. There are consenting parties.
No, you can give something, but you can't say that since he is claiming in a Mulageni tenant. No, you paid that as a bonus, but you are recognizing him as a Mulageni tenant. His case is pending before the Mulageni tenant. No. See, you have recognized him as a Mulageni tenant. The case is also pending for that. You can't say that he is the No, that is it. Whether he is asking for a more amount, he is saying that sale deed is illegal or what. I am not deciding on that. Only that hurdles for this, he is claiming rights over this property. That is Mulageni tenant. Somewhere you are also recognizing that case is pending. Then his right has to be protected or not.
The entire document is null and void. He has to take that to the other board. You can see for the that case also we got into this one report. There are one aspect of the card. But he has taken that into the only. He cannot do this. Nothing successfully. I think by that yes, right. It's not detailed. Very exactly this aspect. And see, I get the objection going. You there will be index. Now make a distinction. I got between an innocent person.
Yes.
And a good word where everything is filled.
Yes.
And it's not blatantly. That's it.
Yes.
And of that, it is such person to polluted the law. I think filled is okay. I mean, I want to make a new thing.
Yeah. Yes.
Order dated 9/6 part in that bill. 9/6.
Now that
Statement competition.
Yes, statement of objection. Bill number 3. Yes.
Copy of the order. Nice. As indication in form number 28 may not be within 6 days. Next. Order is 17 and 14.
Yes.
Yes. May not continue. Consistent order is with us. Next. We could have 14. 20. Copy of the judgment dated 48. This is important. Right? This lady may not. Another way to assume my lords. Give me the change in question. And the remnant as it may not order that change in question.
Yes.
And if it is passed. Within 30, judgment is passed. Next, election.
And judgment above.
A judgment what is that may not other like I said, that in question. Right, trouble, my question. And that's what holds the trial record and frames the issue, the APS contest after that trial record holds. This another way to check my last. And it is and allow the citizen, it is granted. Each
The thing is, when that prior itself is sought in that suit is not entitled, best remedy is to rejection of claim.
That's true. That's the effect of it.
See, when that rejection of plaint is not made, when he has played for an set asiding that sale deed. No, if it is a frivolous suit and all, therefore, Order 7 Rule 11 is there that we have not made any attempt.
First stage is it's urgency considering the application for temporary after they ask this whether the case is part of the yes, but that's good. I am only submitting to my lord sitting in appeal over the judgment whether my lord are coordinate vote from that very good. Is my lord here on the basis of the doubt of this is over you. That was my lord. That is good bad. Even the customer side this change is over. This case is over. That was
yes.
That would be the number one. The base of 2,500 is not.
Yes.
That would initial content, no matter the limited number, like 230 degrees, is part of the not highly ordered. But at this stage, any whether and these are these comes. You are my lot, I got my lot.
Yes.
Praise the platform has done a right job, my lot. That ordinary question. If you truly
Yes.
and the interim changes matters on the board. On mega basic is first condition in there are two is date of publication are from state government. For that proposition will not first is 2000.
That limitation act itself is there. Why do you want to relate? Yes.
Again, not there. Limitation very good. From the data knowledge of the that's why you put that in my heart. Instead of not allow that.
No, I'm not here declaring that it is 3 years barred by that. If I say that, then nothing has been left to the trial.
I am submitting this. I am submitting the value.
Yes.
I mean, not decide the matter. That would decide whether the value will be. That would like to see whether the is or at that stage they will that's the right. At that stage,
Yes.
and number two, if a person comes to the court, reject it. That's a not to leave to deny the leave.
Yes.
So that would help legalize it. I will just take my law up. I'm not repeating.
No, let him answer that questions. Let us see that and delay. Let him answer. Then we'll see.
Today, you know, the stamp number, we don't know the document is not stamped. Court may not looking the document and immediately understand it. Based on unstamped documents.
Yes.
Because they would help to somebody doing the.
Yes. Yes.
And it's also clear of.
Yes.
Admit the transport to one paragraph. The transport. The transport is analyzed because. Page 32 minutes, page number 32.
Page number?
32 minutes. Paragraph 17. Page number
32.
Appeal.
ಏನಿದೆ ಜಡ್ಜ್ಮೆಂಟ್ ಇದ್ದಂಗಿದೆ 32 ಅಲ್ರಿ ನಾವು ದಟ್ ಇಸ್ ನಾಟ್ ವಿಚ್ ಇಸ್ ದಟ್ ಇಂಪ್ಯೂನ್ ಆರ್ಡರ್ by degree with the cost ಇದು ಡಿಗ್ರಿ ಇದು ನೀವೆಲ್ಲಿ ನೀವು ಹಾಕಿದ yes 32 yes yes
mainly based on the assessment and dependent on the planning. Entered into the same date that other than the quantity and the rate of nature of the way, state signature and the but the second another understand maybe and goals. In other words, it's not see, it's all you have to do 150 lakhs, 200 lakhs, but only what for calculate.
yes
It is 2111 to the GB. Okay. The app state that when the content, the user state it is going to delete the entire state consultation and the super data and vendor. Not decided the vendors are the unpaid sellers. Therefore, there is no new way. They have to cancel that consultation technique and the document. But all other things we have to do is about six and the burden will be on like on data to the statement. Anything that is case, if it is there and all take note of the board schools of that people. limitation. Date of knowledge, introduction, date of limitation will be the date of giving knowledge. It always for the party pays the food to show that the thing is in time. Thus, in case of the 55 beyond their development here, then they would have ever and then do the music in player. That is the government of more than the time. Every result becomes the real knowledge.
Yes.
Then paradigm. So this proposition of form and position by lot.
Yes.
Paradigm. Dependents have specifically contained the theory in the picture of fan to 25 or 21 as a verification. In the regard, and student limitation generally, this is the problem. Generally, this question of judgment record will be used as physically stated a party by support.
Yes, you have read that. Let him argue. Yes. Yes. Yes.
And order party.
Yes. Yes.
Because that can order
Yes.
I can take my parity.
Yes.
Very often with a lot of
Yes.
feeling.
Yes, sir.
It's not decision. That decision has been shown to have or an important of regulating grant of the interlock and accumulating the side of decision is said to be an unconditional. The conference will not create anything. And simply the difference of the one thing that would be the one which by that would was literally possible. That's something. One reaching by the code was literally possible. Normally not justifying the side of the equation. Solely on the ground that you can consider the matter. That is not going to be. Education and medical that would be very. We should act the upgrade of that different. Not educated. That would be exciting education. This picture is a lot. Well established. Really, it's going to be a lot. This principle has been reiterated again by the other people as far as Indians are concerned, where related gains are made. But the other people are laid out. Ambala Sarabai. Second edition and main.
Yes.
Yes. The cardinal principles.
Yes.
Considered in Kalpat Kumar that
Yes.
satisfaction that is line of integrity by itself is not sufficient to gratify. Other than that, all in this case, the whole result in it. We can the party and no other area why the party except one to grant image and it gives protection from the consequences or apprehended injury or injury. However, and the more physical possibility is depending, but it's only that the injury must be one that
No, that is what that, see, if it is that injury is compensatable by the monetary benefit, that cannot be granted. That's what I said, that given a bank guarantee and to direct them to dispose of, do it whatever you want, instead of going all these things. Now, if you are relaying this judgment says, see, even then if he has make out a case, if that irreparable injury, it cannot be compensated by that money, then only court can interfere and grant that. Then if you rely on that,
By reason may not be is granted
yes.
by the court. I undertake to make that clear. That condition can be imposed. May not be a problem of this. I ask for the counterpart.
Yes.
Now, what if this may not be okay to you? Then again, from there, the benefit again, but now, who goes is the employee? 50 lakhs is already paid. My lord,
1.5 crore.
I don't, there is an accidental, maybe I will not enter any more, and my lord, on the court says some amount, 20 lakhs, 50 lakhs, some amount is not paid, and then again, I have to pay. And amount will be like
No,
that.
that surety can be given without that amount.
And I will, my lord,
Surety,
we grant, we
surety, is- yes.
submit the surety, my lord, will be, what's up, my lord? Who introduced the surety with the
Surety in respect of some amount. ಅಷ್ಟೇ. Surety ಅಂತಂದ್ರೆ ಪ್ರಾಪರ್ಟಿ ಯಾವ್ದಾರ ಕೊಟ್ಬಿಟ್ಟು surety you can give that. Surety is like that.
property offered by God.
Yes.
And the
ನೀ
surety.
ಇರೋ ಪ್ರಾಪರ್ಟಿ ಒಂದು surety ಕೊಟ್ರೆ ಆಯ್ತು ಅಷ್ಟೇ.
That is only when my lord. My lord.
No, I'm not. See, just I'm discussing. I'm not at. You want to argue? I will see that on merit. What are the possibilities I am asking? No. Ultimately, after hearing him, if I come to that, again, instead of hearing, I just ask. Yes. Yes. No, he wants to establish that he wants that absolute interim order. That will see. Yes. 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 Yes.
I want to read it in kind of first is not the high court of the really medical.
Yes. Yes.
What is the business comes up, my lord.
Yes.
He challenged it. The 19 March he said he came to come to court.
Yes.
He come to court. He does not, my lord. So this is one ground.
Yes.
First ground, the high court, the delay made. It may be active and in the very act of the delay. The revenue taken, present one contact of sale of 1, 2. Delay until beyond the period is there. Third party having rights.
Yes.
No, my lord. Para 20, expected question my lord. 11.
Yes. Yes.
But they must be such that representation the conduct neglected the case directly responsible for individual to change his position.
Yes.
That is the 19 itself.
Yes.
I am not a construction, one of the construction. And one of the construction, allow the construction to go on.
Yes.
3 years, the construction is completed by itself. Para 20.
Yes.
One is limited. This will be much limited. Very much consideration there are body.
Yes.
Part of the consideration also the party taking the jurisdiction of the court and they refuse it together unless the concept was free from blame. Since the litigation will be immediately later. Party the jurisdiction of the court has to show that he himself was at fault, that he himself was responsible for getting the data.
What is the writ petition number?
Petition number is
Yes.
WP 28187
28187
dash 88 87 88.
88
Of 2014.
2014.
My lord, the date is on.
No, no. Is there an interim order there? Yes. Yes.
On the base of it has to be allowed. Registered documents are not moving any deed of the last century. But there is a law registered document. This man was cheated, my lord, 92-year old man in the guise of this. And my lord, the first defendant himself is admitted. A criminal case has been filed, my lord, that has been withdrawn. Ramavish, I will what? Last on that. Your Honor,
Yes.
whether it is ignorant, etc. That's the case of that. This is a case. That's this all goes to 90. June 19, party. Only. And patient one my lord. Jobs were is a take party.
Yes.
Second, man is the landlord.
Yes.
And the court is the property, my lord. Court is on the court and is the landlord.
Yes.
So the claim by the tenant. That is disputed that the court held the landlord. Second petition on the court.
Where is that?
My lord. Number 3. Number 2, my lord. 3 facts. Which is the village of the land buying of the land for Karnataka in Mamuda, in front of the school. Court expect the land they hold in Tamil Nadu, the ownership of the petition is 1 acre in court. 1 acre in the entire court, the first response. Is an unrestricted rule against it, maybe further. And releasing this my lord. You are not a poor person. Illiterate person, my lord, we evicted from the last my lord, my laws helping hand to either asking to demolish or asking me to evicting my lord. And where I transport and distributing my lords, the disability, my lord, not be proper in my position because this is a rich person. We are the due to the right.
Yes.
Should the house protect the 20?
No, this is related to some other property.
Now he says, he says, I did not, therefore I might bring the start of the gate of yes. This cannot be at all.
No, that is there any bar for that to claim a Mulagani tenancy in the person who is holding a land? No, I'm not asking that. I'm asking. No, is there any limitation that to claim a tenancy he should not have more than this extent of property? Is there any bar? No, I'm asking that is there any bar under that Land Reforms Act? Person who is suppose if the person holding 100 acres, he is also cultivating somebody's land. Can he claim an occupancy right? Is there any bar under that act? Where is that?
Urban land ceiling act has been repealed. This is not
Under the Land Reforms Act.
that is not for acres and acres. Not 20 acres, 40. It is very small holding. That will not come here. That is ground level. That is not the ground level.
Yes.
And here also not is significant. Here also.
Yes. 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 Yes.
But my opinion, my subsidiaries, the lordship will take similar the my papers.
Yes.
Page 102.
Yes.
Not 102. But the order dated 4/3/22.
Yes.
I suggest the plaintiff has filed IA number 200 of order 39 rule 192 section plan to pass an order of execution. Agent said, so he was paying for 200 and for the engineering. They need to have special property or motion thereof or engineering create the income rate or
or changing the nature of the field by making any kind of construction in the then entering order injection to the same effect in the that is the problem with the point. There was upon going through the fact that the propagation is the ratings and the documents related by the rating. As the convenience is seen in view of the rating, if expanded is not granted to state the defendant, continue the alleged independence and thereby causing a retirement injury to the brain. No prejudice or injustice will be caused to the defendant. Hence, I proceed to pass the following. Application under so and so is allowed. The defendant thereby agents, servants or any of claiming through or under them are restrained by an order of temporary injunction. Alienating of scheduled property or portion thereof, or creating income or changing the nature by making any kind of construction. Even that order of the construction also violated this. I don't know, this is more than 1 year, 13 to 22.
Yes.
I mean, 4/3/22. We are in 23 August. But they violated this and continued to construct.
Why you have not filed contempt there?
I have filed my lord, I don't know what has happened and not.
Yes.
Now, my lord, my suit to lordship, their conduct has been repeatedly saying, how did he get my lord occupancy? I mean, these orders of the corporation, all that well. Now, my kindly see what I have written the plain. And immediately trying to change it about more than 19 years ago. Lord, he is not able to properly work and all that. But he was made to, an agreement was, he understand.
No, ultimately,
Yes.
you are relying on that understanding of that MOU.
Yes,
There your claim is 2 crores.
yes.
50 lakhs has been given.
My lord, I am relying on that only to Bangladesh. Stand that argument will not come here at all. Now, my lord, unless the entire consideration cannot.
No, you have, according to that MOU, you have agreed for 2 crores.
Yes,
2 crores you have agreed.
yes.
50 lakhs they have given.
50, but my lord, you told my lord, the valid parties, my lord, your lordship says, my lord. I have to take the documents in favor to purchase the site.
Yes.
Consent and all that, as in the after MOU. But kindly see the clause here. The first party shall give his consent to second party executing the registered sale deed and all that. And I was taken to the sub-registrar's office. He was all alone. His son and wife are in poverty. They are not permanent residents. This man was alone and not his aged man. But he was taken to the sub-registrar's office.
Yes.
And in the guise of petitioning this agreement, all given to understanding that the agreement will be registered because an MOU and all. Kindly see under this document itself, I had to surrender the position. They had to make arrangement. Therefore, I did not realize this. One side you will not make this speak up. I had not got it. I was only.
No, but you could have given a police complaint.
Subsequently, after realizing it, that's what I said. After realizing it immediately in 2019, I have given a police complaint as against all of them, including some 2-3 lines.
Then when?
In 2019. 2009. Kindly see
Date.
my lord.
Date has come.
My lord, these honorable would be pleased to pass the FIR in crime number 25/19 on the file of the 3rd CJM court in Mangalore for the offence mentioned under so and so. They did not, they have not challenged. Parties have not challenged. Who has challenged that criticism by filing 482?
No, but the date of complaint.
What he has said in the private complaint, I went to the police station, he did not receive and all that.
No, what has happened to that complaint? Charge sheet has been filed.
No, they were not able to dispose of in March 20th. They are very influential people, builders, they did not find.
Yes.
I kindly see the position where I am. I will not see the end of this litigation out. It will have judgment today. But it will have, but if you are good to 1893 or 94 years, he's not keeping.
No LRs. There are no
They did not know. They did not know whether the land is. Not kindly see, my lord, the lawyer himself, my lord, has withdrawn his complaint. Now, who has, my lord? Two aspects, my lord. This agreement, my lord, is with the 3 persons for joint.
Yes.
One is the first one is one array children side. I don't know who is actually was, but he himself has admitted my allegation. That's what I said, my lord, saw it on the other hand. Kindly see the written statement filed by prima facie. What else?
No, that is what that he is appearing for him. That.
Yes, he is also there. But subsequently, he was also admitted. That's why he has come out. Kindly see his own written statement, my lord. Filed in the suit. What else is necessary is my humble submission.
Who is he?
But he is the first party to this document. Is he?
That is Sharda Bai.
No. Well,
What he is saying, whether he has filed it or not, he has to say.
It is there. What deed is there? What deed is there? And I'm not saying when it is paid person. All
Yes.
I got it. Never paid.
No, whether it is filed in the court or not.
After this order.
Anyhow, that he has filed an affidavit saying that this is false. No, it is an affidavit filed to the court, Mr. No, that you have filed to the court. You know the consequence. Our reporting, they're all take it that court has a granted. Anything can be filed for their adjustment. No, if that would be the case, you can make out he cannot make use of the court for his benefit. Yes.
Anyhow, statement cannot be because after the order, this is my.
Yes.
I don't know how statement can be received after the received it. I don't know how. Nothing is there. This cannot be used at all. Yes. 22 October.
What is his statement?
Kindly see my paragraph 4. Paragraph 4. It is true to certain extent that the plaintiff agreed to surrender its possession and enjoyment over the scheduled property on certain terms and conditions, and as a result, the plaintiff agreed and decided to execute a memorandum of understanding to reduce the terms and conditions agreed. Then the defendant admits the execution of the MOU and the terms and conditions agreed upon in the MOU. In fact, at the instance of the defendant number 2 and 3, and the counsel who represented them said it came to be executed in the guise of execution of the MOU. The defendant humbly submits that he is not a party to any of the illegal acts committed by the other defendant. If any, this defendant never colluded or even up with any person to reach the plaintiff. Moreover, he has neither conceived nor joined hands with any persons and got executed and registered in the state in respect of the right of the plaintiff over the scheduled property as there is. In fact, defendant number 2 and his advisor who got the document registered without honoring the conditions stipulated in the MOU, this the defendant has only paid a major portion of the sale consideration as requested by defendant number 2 and his legal advisor. This defendant is just an investor and hence he cannot be able for legality. Fraud committed by defendant number 2 and others. So there is a clear-cut admission made by the first defendant who has signed both this document. They say it itself, prima facie, and my lord, Even without that, as I said, more than 1 year ago, when on an entry not and that is in operation. In fact, as on today, that entry model is still modified. Your lordship, thank you while admitting the further construction, that portion to lordship said, let them cover the construction. The fantasy your lordship order. Now there was a bar injunction restraining them from further construction. They proceeded. And he goes on commenting on my conduct. This criminal petition, my lord, when I filed against the lawyer, my lord, therefore, in fact, the decision which my learned friend has even with regard to injunctive principles, my lord, are well settled, and that decision fully supports my case. My lord, because irreparable injury, my lord, balance of convenience, my lord, an entry model is to be granted to protect the property and to keep the state. But if the holder sells and creates third party interest, I can't find it. He will sever third party interest. And he will be out of picture. Total. But the consideration made by the court below, which he has been asking upon, is that there is a registered document and therefore all that is binding. You can't argue against that. That is not that legal position at all. When a document itself is in challenge, when a document itself is in challenge, then no recitals made in that same need can be binding. When I say that
one of the flats you don't sell it, keep it pending. One of the flats,
one of the flats will not be done. I have got the.
No, I will hear you. I'm just asking him that. Yes. Yes. Yes.
That will not be. That will not.
Yes.
Here, put 3 flats.
Yes.
I have got the copies of the registered cities.
Wait.
What's 10 lakhs each? Registered amount is 10 lakhs for each. I have got the copy of the document.
What is the value of that this thing there?
5,000 he has told the properties, built areas of as per the registered document. I will pass it on the copy and undertaking that is not pursued is to other cases.
Atwa settle ಮಾಡ್ಕೋಬೇಕು ಅದನ್ನ cannot stay. No, that is for you to settle him and withdraw all the cases. It is not concerned this case. Here I am saying that via media, how can you protect both of them? Yes. That I am not relying on that. That I can't. I can't rely on that. Otherwise, I have to import the documents. We are not deciding on that way.
This is the 3 sale deeds. 3 sale deeds which he has registered. Entry mark was there in this picture. Commenting on my conduct. It was being continued by not 2-3 times. But once the map was posted for wailing process for one of the respondents not submitted. But I thought, my lord, I have made a request to the court to continue the entry model anyway, my lord, in the order, saving my mistake also, my lord.
Yes.
Wailing process for one of the respondents map was listed. Unfortunately, entry model was not continued.
Yes.
But immediately I could not post 4 plans. Immediately taking advantage of this. And my lord, as per the registered sale deed, my lord, here, it is for about 10 lakhs. 10 lakhs, my lord.
Is it the value, Mr.
Yes.
Is it the each shop's value is only 10 lakh?
The registered document, we can deny it. This is the registered by anyone. I will just.
What is the value of the square feet there? Pardon me. ಅದನ್ನ
He has ruled it. It may not be anything, it is a point, may not be, if we are not situated, the property also will give the, along with the.
Yes, let us see that, what you say about that limitation, Mr.
Limitation may not is from the date of the knowledge. Limitation is from the date of the knowledge.
No, you are in a signatory to that.
Signatory may not, but I did not know, may not, that I am saying the same thing, that's what I am saying.
Yes.
But I did not realize this fraud being paid. Both documents are executed on the same day. Ramesh. Both, but if their defense is, interestingly, their defense is the amount is fabricated by. Unless they establish it, a lot of that is fraud is suspect. But they say in the amount mentioned there and the check and other details mentioned in the MOU and the same deed are same. Kindly see this. And which is admitted now by the other party. Same thing. Check everything, which shows that it was not got up at all. This defense is, this is a fabricated document. There was no intention of signing any MOU. Directly it was taken to the sub-registrar office and taken it to the registrar. Normally, my lord, no, they leave like that directly. That is the difference.
Yes.
Therefore, my submission is, my lord, he has sold a flat after he said it, my lord, after public. It will be around 3,335 units per square feet here. Therefore, keeping one shop and all that will not serve any purpose. Unless my lord, because that builder, my lord, who has financed, my lord, he has also been like this is what I am. Check homes cases and all that are all. So this is a deliberate intention. Why he vacated, my lord, he has been harping upon the litigation. Not is an old man, he was staying alone there in the premises. It's a registered document. They would not have known this.
Therefore, I am not asking to give any money. Otherwise, you will start another litigation. Now you give a bank guarantee. Close it.
One second, one submission. My lord, they were forcing him to vacate. They were troubling him like anything. This Mulaka, she is not getting anything done. They were troubling him, they were forcing him, they were not allowing my lord to repair. So from 2010 onwards, continuously some litigation, some court and all that. That's why he went on filing injunction to complaint. So he can't resist it. Therefore, ultimately agreed, my lord. These two courts in terms of a very nominal amount. The land value is much more.
But you are not disputing, you are relying on that.
Which one is
No, he is saying that 2 crores, but sale deed is 50 lakhs. No, that ultimately you have restricted your rights over the properties is only 2 crores. Therefore, I am just thinking that how it can be protected for 2 crores.
We cannot be,
Yes.
Now, secondly, my lord, which your lordship is whenever admitted, my lord, I have quite the matter is not still land converter. And converter and that is not interfere like that. But converted in 2003, 2003 or 2011. It was that shows my lord as on 1/3/1974, it was an agricultural land. I was entitled for the grant of occupancy right, my lord, to register document. It is not simply my lord, if it is concluded through documents, my lord, he has to be granted. Then once I say, my lord, the court comes to the conclusion that it is I got the information or it will be a registered deed. The land automatically vests in the state. But I do not have told my right was only to get occupancy rights, my lord, with the act from the state. The state becomes the owner. You are not aware of that principle. There is a decision on the center power. With the state, either the landlord or the tenant strike. Once it was held as a tenanted land, as of 1/3/1974. That question itself is pending. Apart from the other things, it is pending before this honorable court. My requisition is not rejected. They were able to get order there, my lord. My appeal has been rejected by the KAT. Tribunal has rejected my application. That's all.
Then I will
Land is pending. tag this matter along with that reputation.
tag this matter along with that reputation.
That is pending. 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 That is pending.
If repetition is goes, everything will go.
As far as the other case is concerned, that concern because we have hundreds of cases pending before it's on the board. He is taking advantage of their tendency cannot the application is there. Not the implement.
His life is only on that land reforms matter. If he goes, then he has no other right.
Because that's what our case is. And we don't move the matter.
No, even you have not moved that matter for disposal.
I am good. Whatever my lord, the person else, but handling the matter, my lord, he got appointed as a deputy. Okay.
Repetition 28187.
No, almost 10 years it has pending. Now that no interim order when the matter is pending in the High Court, they will take they'll take that advantage. I will. How can you are telling that?
Can you think that it's not possible that there is an order being solved for 19? That's why 19 you will. So you know how to file application after that. And that's why you can consider state and place where they educate the customer, who is the landlord. We come to people and the education.
No, we will tag this matter to that.
That's how my lord. They ask the person. Because by this order, my lord, they reject this order.
That's my lord. This is a builders, my lord, who has been like.
No, the problem is this land is vested with, if it is a tenanted land, if it will be vested with the government. If it is a tenanted land, tenant is not proved, it is a government land. You cannot get a right to sold it.
It's not on number 7. That right was over. We tried on number 7A.
No, whatever may be seen, if it is in a.
My lord, what the authorities have
No, that doesn't mean that High Court has no power to interfere. Then, see, on the other hand, we are giving in a permission to sell the property which belongs to the government. That is what I am thinking now. See, what the given tenant failed to prove, that land will be vested with the government if it is a tenanted land. Then you are taking and enjoying that government land. Tomorrow, suppose if you say that he is failed to prove the tenant, but court held that it is a tenanted land, then it will be vested with the government.
There should be determination of the land and this is a case, not form number 7. Form number 7A.
7A is the extension period.
Form number 7A would be when go to the records. Then only can be landed in solid court.
That is true. That is pending before this court to decide. That no, we both the. No, if both the courts, tribunal has said, High Court can't interfere.
They are not to stay.
Yes, I will pass an order. You will be restrained from not to alienate. You can construct it. You cannot. Then you can't alienate. No, now that unless that it has to be decided. No, tomorrow if we held that it is a state government property, I cannot be permitted by this court. If you want, then I will tag this along with that. Otherwise, I will restrain you to not alienate. Otherwise, I am permitting you to sell that government property. Yes. Bernard Council for Appellant submits that. Is claiming a Mulagini tenancy right over the properties, which is pending before this court in WP number 28187 of 8-88 of 2014. This suit is also arising out of the very same property. Under these circumstances, office is directed to post this matter along with the WP number so and so. Since the parties has submitted that there is an urgency in that matter, office is directed to take necessary order from Honorable Chief Justice, post before the appropriate bench, any date on 21st, 22nd, 21st. You get it? ಒಳ್ಳೆದಾಯ್ತಲ್ಲ 21st, yes, 21st. Interim order granted in this case, continue till next date of hearing. If it comes, get ready in that. First we'll decide the writ. Yes. Now that first writ has to be decided. If writ goes, automatically it will go. No, that's what I said. Parties are urged that there is an urgency. Therefore, directed so posted on 21st. Sarvagil one big. Survey copy. Who is appearing? Have you filed an wakalat? You have also not taken that. Yes, you sir. I tried to serve one set of copy, Mr. Bernard Council, but that is not this writ petitions order. Why I have mentioned he can Keshav, but you serve a copy. Yes, one full set can be served. He can get ready. Yes. Citations are not real. Yes.
Number 65, application for appellant, 1970.
Yes, where is that?
Very connected matrix. Very connected matrix.
What is that connected? What you said? This is what is the survey number? But different, not. So this is also same notification. One. This is different, madam. For the land, the LAC dated land situated in the same judgment was constant of entertaining the principal. Where is he? Yes, we'll have it on tomorrow. Tomorrow. Okay. Thursday. Yes, yes, Mr. Where are you? You are not there.
Number 63, for appellant,
Yes. Which one? 63. No, what you said, Supreme Court. Judgment. No, now that Mr. Council, Where is that service, Mr.? You see the acknowledgement, it said that. Yes. No, we will send it back. Then we will impose some cost. Let him pay the cost and then. That.
Says, two paper publication order 5/17 has to be compliant.
Where is that?
So, some service under order 5/20, this is an exception to the Northwest Board of Service. Ordering substituted service under the province. Someone should dependent return answer to the report of the value of the dependent department. A serving officer not following the procedures stipulated under 5/17. They after an application for the value transport ordered subservice by way of paper publication in the. If passing the order, transport paid compliance fine for requirements of order 5. But also include the relevant project as a service of projects contained in
So that first there is a complaints of order 5 rule 17.
Yes.
Yes.
Especially this compliance of 5/17 should be there before going to 5/20.
Very Para 13. The submission that order 5 rule 20, it was not necessary to affect the copy summoned to the house of the in the defendant. Once the court has directed service of publication news to the value, there was a clear breach of procedure prescribed and responsible due to the creation of mind, the requirement of satisfaction prescribed in the provision of court. Justify coming to the conclusion that extraordinary judgment under Para 19. Yes, 14.
Evidently, as the report plainly indicates, was unable to find the dependent address. They did not indicate this. So it must be CS part of the house. In this case also there is no such.
Yes.
Para 14. The report of the value does not indicate that substance was annexed or a conspicuous part of the house. Get the address mentioned in this. 15. The application of service was filed into the branch. I was with the executive order was passed. Order 5/20 requires the court to be satisfied that there is a reason to claim that depending is in the court. Except is not that for any reasons.
Order 5 rule 20, they need not satisfy that order 5 rule 17. It's independent of this thing. But there should be any reasoning for the court to believe that there is a 520, there should be application of mind.
5/20 there should be application before ordering
Paper. No, 5 normal process is 517. If 520 has given a power to the court satisfy that he is avoiding, then affixing and paper publication was an amendment.
Paper publication should be a reason order, satisfying the contents mentioned in 5. Application
No, orders that is yes, right. No, that's what I asked. No, ಅವಾಗ ಅಂದ್ರೆ ಮನೇಲಿ ಇದ್ದು ಅವ್ರೆಲ್ಲಾರು ಹೊರಗಡೆ ಹೋಗಿದ್ರು ಕೂಡ ಅಫಿಕ್ಸ್ ಮಾಡಿ ಅಂತ ಹೇಳ್ತಾರೆ. ಇಲ್ಲ ಅಂದ್ರೆ ಲಾಸ್ಟ್ ನೋನ್ ಪರ್ಸನ್ಸ್ ಹ್ಯಾಸ್ ಟು ಬಿ ಸರ್ವ್ಡ್. ಯಾರೋ ಸಿಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಅಣ್ಸ್ ಬನ್ನಿ ಅಂತ ಹೇಳ್ತಾರೆ. ಅದು ಅವ್ರು ಮಾಡ್ಲಿಲ್ಲ. ಅವನು ಏನ್ ಮಾಡಿದಾನೆ, ರಿಟರ್ನ್ ಅನ್ಸರ್ಡ್ ಅಲ್ಲ, ನೋ ಸಚ್ ಪರ್ಸನ್ ಅಂತ ವಾಪಸ್ ಕಳ್ಸಿದಾರೆ ಅವ್ರು. ಅವಾಗ ಕೋರ್ಟು ಇಲ್ಲ ಇವನು ಅವಾಯ್ಡ್ ಮಾಡ್ತಾ ಇದ್ದಾನೆ ಬೇಕಂತ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಏನಾರ ಬಂದ್ರೆ ಅದಕ್ಕೆ ರೀಸನ್ ಕೊಟ್ಬಿಡ್ತು. ನಾವು ಅದಕ್ಕೆ ನಮ್ಮ ಹೈಕೋರ್ಟ್ ರೂಲ್ಸ್ ಅಲ್ಲಿ ಏನ್ ಮಾಡಿದೀವಿ ಅಂದ್ರೆ ಯು ಹ್ಯಾವ್ ಟು ಸೆಂಡ್ 3 times notice. High-Court rules and therefore we are saying that 3 times notice, then we will give a reason. Means 3 times he is avoiding, therefore he has been permitted to paper publication. Yes, Kavali. This appeal is filed by defendant. Order 43, Rule 1D, challenging order dated 19 September 2022, passed by 24th Additional City Civil and Session Judge, Bangalore. Miscellaneous number 761 of 2014, whereby IA filed by the defendant under Order 9, Rule 13 is rejected. Plaintiff, for the convenience, parties are referred to the ranking as per the trial court. Plaintiff has filed a suit for their injunction. The notice in respect of respondent has been their injunction. Notice summons issued to the defendant has written with RPAD, which has been marked as Exhibit 39. No such addressing, no such person in that address. Trial court permitted the plaintiff to take out paper publication under Order 5, Rule 20, and on the basis of that paper publication, service in respect of defendant has been held sufficient. He has been placed ex parte. Judgment and degree has been passed on 10/3/2011. After coming to that notice, the plaintiff defendant has filed the miscellaneous petition under Order 9, Rule 13 for set-asiding the ex parte judgment and degree. The same came to be dismissed by impugn order. Being agreed by the same, defendant has filed this appeal. So and so learned counsel appearing for defendant contended that there is no compliance of Order 5, Rule 17 and Order 5, Rule 20. The trial court, without giving any reason, has permitted the plaintiff to take out notice by substituted service by way of paper publication. In fact, the defendant is not aware of suit filed by the plaintiff before the court in OS number 4112 of 2008. The trial court has passed ex parte judgment and degree. Immediately after come to the knowledge of defendant, he has filed this miscellaneous petition. Trial court, without considering that contention raised by the defendant, as rejected. Hence, he sought for allowing that appeal. In support of his contention, he has relied on judgment of Apex Court in case of 2018-2 SCC 649. Per contra, so and so learned counsel appearing for the plaintiff has contended that summons has been sent to the defendant to his last known address. The cover and acknowledgement has been written with postal shara that no such person. Since defendant is trying to avoiding that summons, the trial court has permitted that plaintiff to take out notice by substituted service by way of paper publication. Accordingly, notice has been taken by paper publication after complaints of provisions of Order 5 Rule 20. The court has held that notice is sufficient to the defendant and he has been placed ex parte and judgment and degree has been passed on merit. Considering the same, the trial court has rightly rejected miscellaneous petition filed under Order 9 Rule 13. Hence, he sought for dismissal of the appeal. Heard the learned counsel for the parties. Peruse appeal papers. It is not in dispute. Plaintiff has filed a suit in OS number 4112 of 2008 for their injunction. The trial court has issued summons to the defendant. As per that, Exhibit P7, the postal acknowledgement written with postal shara that no such person in that address. The Apex Code, in case of Neeraj Relators Private Limited, 2018 to SEC 649. As held as follows, para 14 and 15 of it. In the case in hand, trial court, before permitting that plaintiff to take out notice by substituted service, has not given any reason as per Order 5 Rule 20. Therefore, placing the permitting that plaintiff to take out notice by paper publication is contrary to the provisions of the Act. The trial court, while considering the application filed by the defendant under Order 9 Rule 13, has not considered this aspect of the matter. In view of the above, the appeal requires to be allowed. Accordingly, appeal is allowed. Order dated 19 September 2022, passed in miscellaneous number 761 of 2014, is set aside. The ex parte and IA filed under Order 13, Order 9 Rule 13 is allowed. The ex parte judgment and degree dated 10/3/2011, passed in OS number 4112 of 2008 is set aside. The suit is restored to the file. Subject to condition, appellant has to pay cost of rupees 10,000 to the plaintiff. Will you appear before the trial court? Yes. Allah read date ಕೊಡ್ತೀನಿ, you can appear. Now it is set aside and restored instead of ಹೊಸದಾಗಿ notice ಹೋಗಕ್ಕಿಂತ. No, I will fix the date. You can on that day appear and produce the copy. ಇಲ್ಲ ಅಂದ್ರೆ ಮತ್ತೆ summons notice ಬೇಡ ಅಂತ. The parties are directed to be parties are directed to be appear before the trial court on 12th. The defendant is directed to pay that 10,000 rupees cost to the plaintiff on or before 12th. On or before ಅವತ್ತೇ ತಗೊಂಡೋಗಿ ಕೊಡಿ ಅಷ್ಟೇ. The trial court ಅಲ್ಲಿ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕ್ಬೇಕು ನೀವು. On same this thing, same property, Bengaluru. And also, ಅಲ್ಲ ಅದಕ್ಕೆ ಆರ್ಡರ್ ಮಾಡಿ ಅಲ್ಲಿಂದ ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡಕ್ಕೆ ಒಂದು ಅಪ್ಲಿಕೇಶನ್. ಈ ಕೇಸ್ ಎಲ್ಲಿ ಬರ್ತದೆ ಮತ್ತೆ ಇಲ್ಲೊಂದು ಅಲ್ಲಿ ದಟ್ ಆರ್ಡರ್ ಹ್ಯಾಸ್ ಟು ನೋಬಡಿ ಹ್ಯಾಸ್ ಚಾಲೆಂಜ್. Yes, we'll direct. And both the parties has agreed in respect of very same suit schedule property between the same parties. The suit is pending in YS 1393 2014, pending in the file of Junior Division Bangalore may be transferred to Rural District Bangalore may be transferred to 14th Additional City Civil Judge Bangalore. Both the suits YS number so and so and YS number 4112 of 2008 may be clubbed together and pass an judgment, pass an order on merit in accordance with law on or before 1 year from date of appearance of the parties. What is the law? 12 9. Yes. Yes.